will not read that instruction again. The court will, however, send that back with the other instructions to the jury. 1.01B, implicit bias, is people's instruction number 3.
Hope it's
Any
not showing.
objection to that, Ms. Schnock?
No, Your Honor.
That will be good. People's instruction number 4 is 1.02. The jury is the sole judge to believe it.
What's the biggest mistake you made at your wedding?
Honey, I love you, but said I do. Not my mistake. I love my wife. I'm going to get in trouble for that, aren't I? Yeah.
Hello, 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 crime spies. Welcome to my big fuzzy Monica from Friends hair. What up? My hot rollers are still plugged in. I haven't used them yet. I've been so darn busy. So the video for closing arguments, the jury has been in deliberations about 2 hours now. The video, thanks to Gisela on Grizzly True Crime, I noticed she was streaming it. I'm like, what? How did I miss this? So this was just posted about 56 minutes ago. So we're going to watch the closing arguments. Defense first. I'm going to be fact-checking the defense because when I was going through the tweets this morning, I'm in the significant minority on this case. I don't think the state proved it. I think that there's a lot of circumstantial evidence, and had the charges been conspiracy, I'd have probably bitten on that. But putting the gun in his hand, I don't see it. I don't see it. And so you're going to have to listen to my commentary on this because I want justice for Rebecca. And if law enforcement dropped the ball by having narrow focus, tunnel vision on the estranged husband, that's not justice, putting someone in jail for the rest of their life. So you're going to hear this is probably the only time I've ever, beforehand, really gotten frustrated. Well, no, I've been frustrated this whole trial. So I'm going to stop talking now, but I'm going to probably interject a few things just to throw little nuggets in your brain. So please bear with me. Please do not unfollow my channel. I'm still growing. But if we don't have a discussion, then how are we supposed to learn anything? We can have 2 different points of view, but I want somebody that thinks he's guilty to tell me why. Show me on the evidence that was presented why. That's how it works. So at the very least, you can sit and watch my hair get fluffier and fluffier. Okay, are we ready to start? I'm going to just go back and I'm going to put the judge in 2 times speed.
We are back on the record on
and they do not have
CF
closed caption turned on for this. So
Mr. Bliefnick is present in court along with his attorney, Ms. Casey Schnock. People appear by Assistant State's Attorney Josh Jones and Laura Keck. And while we are waiting, then we are going to have a formal jury instruction conference. And then Ms. Schnock, are you ready?
I'm ready. I don't know if the state has updated the instructions since yesterday afternoon or not.
The only thing we did was, we haven't updated anything. We're just going to withdraw
Okay.
the 2 instructions we talked about.
Okay. So people's instruction number 1 is 1.01, the function of the court and the jury. Any objection, Ms. Schnock?
No, Your Honor.
All right, that will be given. People's instruction number 2 is 1.01A, the preliminary cautionary instruction before opening statement. Any objection, Ms. Schnott?
No, Your Honor.
That has been given. The court will not read that instruction again. The court will, however, send that back with the other instructions to the jury. 1.01B, implicit bias, is People's instruction number 3. Any objection to that, Ms. Schnott?
No, Your Honor.
That will be given. People's instruction number 4 is 1.02. The jury is the sole judge of the believability of the witnesses. The people are presenting the instruction with only the first paragraph. The second paragraph about the defendant testifying is removed. Any objection to that, Ms. Schnott?
No, Your Honor.
That will be given. People's instruction number 5 is 1.03, arguments of counsel. Any objection to that instruction?
No, Your Honor.
That will be given. People's instruction number 6 is jury note-taking. Any objection to that instruction?
No, Your Honor.
That will be given. People's instruction number 7 is 1.09A. It's a civil instruction, but it's an instruction concerning extended media coverage. Any objection to that instruction?
No, Your Honor.
That will be given. People's instruction number 8 is 1.09B. Again, it's a civil instruction. It's entitled, when the news media was present at any portion of the trial. Any objection to that instruction, Ms. Schnock?
No, Your Honor.
That will be given. People's instruction number 9 is 2.01, the charge against the defendant. Any objection?
No, Your Honor.
That will be given. People's instruction number 10 is 20.01, enhancement extended term factors. Any objection to that instruction?
No, Your Honor.
That will be given. People's instruction number 11 is 2.02, the charges against the defendant. Any objection to that instruction?
No, Your Honor.
That will be given.
I think we went over these
Instruction
yesterday.
Number
I'm
12,
tweeting.
which is the presumption of innocence. Any objection to that instruction?
No, Your Honor.
That will be given. People's instruction number 13 is 2802, enhancement as to the presumption of innocence. Any objection to that instruction?
No objection.
That will be given. Then we're going to take defendant's instruction number 1.
Okay, rumble's
which is
on.
the
I
failure
see
of
ya.
the defendant
I
to
see ya.
testify. Mr. Jones, any objection to that
Good,
instruction?
good.
That will be given. Then we have people's instruction number 14, which is 3.01, the date of the offense charged. Any objection to that, Ms. Schnock?
No.
That will be given.
I just sent out a tweet.
People's instruction number 15, 3.02, definition of circumstantial evidence. Any objection to that instruction?
No objection.
It says,
That will
just
be
started
given.
my live stream, day 7
People's
closing
instruction number
arguments, video and
16
recap.
is 3.06
I'm going to talk over him, I guess.
3.07 statements
Join
by
the chat because I'm in the
defendant. Any objection to
minority.
that
Don't think the
instruction?
state
objection.
proved
That
its
will be given.
case. Conspiracy. I'd have
People's
probs
instruction number
bitten.
17
But
is
murder, I don't see the
7.01
evidence.
B, which is definition of first degree
Just
murder.
watch the
Any objection
hate
to that
come in.
instruction?
No
Somebody,
That will be given.
somebody lashed out
People's
at me the
instruction
other
number
day
18, which is 7.02B, issues
on
in first
Twitter.
degree murder
I posted
when
like a
second degree murder
recap
is
and they're
also-
like, get
is
this
not also an issue. Any
effing thing
objection
off
to
my
that instruction?
feed.
No, Your Honor.
Some of
That
us
will
like
be
to be
given.
surprised. I'm like, okay, just trying to be
People's
helpful. Put
instruction
your
number
claws
19,
away.
definition of home invasion, and that's 11.53. Any objection to that instruction?
No objection.
That will
Call.
be given. People's instruction number
seriously,
20
people.
is 11.53C, definition of dwelling place of another. Any objection to that instruction?
No objection.
Mr. Jones, the clean copy,
We're gonna fix that.
I'll
I
slow
have
the
as part of
talking
another
down
instruction on
as
it.
soon as
I'm
he's
going
done
to-
with the instructions.
We'll revert that
I'd
later.
like to
Okay.
skip over it, but
and since there's no objection, then that instruction will be given. People's instruction
it's
number
hotter than Satan's lair in
21,
here. I got 2
which is
fans on and the
11.54,
air
issues in
conditioner.
home invasion.
It's getting
Any
better.
objection to that instruction?
No, Your Honor.
We don't
That
need my
will
hair
be
to
given.
get any fluffier.
People's instruction number 22 is 28.
Did you ever see that episode of Friends where Monica, they're in Barbados or Bahamas or somewhere? Monica's hair
That will
just
be given.
gets bigger and bigger and bigger and bigger.
People's instruction number 23 is
So what's going on here in
2601,
Minnesota?
including instruction, which is also the jury is not instructed on a lesser included offense. Any objection to that instruction, Ms. Schnock?
No objection.
That will be given. People's instruction number 24, which is 28.
Oh, and for those of you that are watching that have listened to Absurd Beats song, the reason he took it off of Rumble is because it's you can buy it on
That will be
iTunes
given.
and Spotify now. So go do that while we're waiting for the judge to get through all of his distractions. My dad used to call instructions
Not
distractions.
guilty of home invasion. It's
So I always say
26.02.
distractions.
Any objection
He used to
that
confuse the
instruction?
No objection,
children.
Your Honor.
when they were little. They're like, Mom, it's
That will be
instructions.
given.
I'm like, I know, but my dad always said
People's instruction
distractions
number
because get it?
26
Like if you are
is 26.05,
reading the instructions, half the time
guilty
you,
verdict of
you know,
home invasion.
don't put
Any
it together
objection
the
for
right
that
way,
instruction?
so you're
No objection.
distracting me.
That will
I don't
be
know.
given.
I always thought it was funny. And quirky.
People's
So anyway, Absurd
instruction
Beats
number
his
27
song that
is
I have had stuck in my
2602,
head for,
which is the not guilty of first-degree murder.
well, for
Any
it was for
objection
several
to that
days, and now it's
instruction?
kind of like waned
will
in
be
and
given.
out. But it's on iTunes now, so you can buy it on iTunes and Spotify.
People's instruction
And
number
also, it's on
28,
YouTube.
26.05,
It's monetized on
guilty verdict
YouTube,
of
so when it
first-degree
gets
murder. Any
clicks
objection
on
to that
there,
instruction?
No objection.
hopefully he'll
That
get
will be
paid
given.
for it. But I have a friend in Minneapolis that his
People's
brother
instruction number
is the
29
bass player of the
is
Jayhawks. Now, the Jayhawks had a really popular song,
28.05,
I'm Gonna Make You Love Me,
allegation not
from,
proven as to first-degree murder
it
with
was a very
charge of a firearm. Any
popular
objection to
TV
that
show.
instruction?
Anyway, so the
That
bass
will be
player,
given.
Mark Perlman, I know his brother Dino. And I just asked Dino
And
if he could
instruction
listen to
number
it and if he
30
had any insight on how that can get on the
28.06,
radio
allegation
here in
proven, which is
Minneapolis. So he's
first-degree
going to
murder
let
with
it
discharge of a firearm. Any objection
marinate
to that instruction?
No objection.
That will
in
be
his
given.
head. He's like, not off the top of my head, but
All
I'll
right,
think
then.
about it.
That is all the jury instructions that have been presented at the preliminary
make you- no, I'll get
informal
that song.
jury instruction conference. Mr. Jones, are the people offering any other instructions?
Other than
Keep
the
in
two that we
mind,
bring
I'm
up before they
53
correct
years
the
old,
errors in the
so-
video.
Okay. Ms. Schnock, is the defendant offering any additional instructions?
No, Your Honor.
Okay, those will be the instructions once they are corrected, and, are we ready yet?
It was,
Are we ready? Okay, anything we need to bring up
it was,
before we bring the
it
jury
was
in,
in a
Mr.
TV
Jones?
Just the only thing I would bring up is if we want to address the people's position after closing arguments is that none of the exhibits at this point should go back to the jury. We're not asking anything to go back to the jury other than the jury instructions.
That I
at this point.
didn't
If they want to see
watch.
something, they can certainly ask that question. We can address it there. But,
All right.
that's what we would request.
Ms. Schnock, what's the defendant's position?
At this point, Your Honor, we're not asking that anything go back to the jury.
Okay. The court would agree, because of the number of the exhibits.
Okay, now
and
when,
the volume of the
Josh
exhibits
Jones
and the
starts
fact that some of them
discussing-
could go back, some of them probably shouldn't go back.
I'm
At
gonna
this
be
point, we won't send
fact-checking
any of the,
because
any of the exhibits back. and
some
then
of the
if
things
jury
I was
wishes to
catching,
request
like
a
on the
review
text
exhibit, then,
messages, those
we will
were
discuss
2
that
years
and
before.
Consider sending that back then. Anything else?
Those
before
were
we bring
2
the
years
jury in, Mr.
before.
Judge, what's the court's plan now that we've done
And
formal
for those of
formal
you who
instruction
have been
conference, does the court want us to go
divorced,
right into close? If so, stuff up?
No,
I
because we'll
know
have to consider
if you
any
compare
motions
my
that are
text
made once the
messaging from like
defendant,
right around the time I was
presses
getting
up presenting
divorced
evidence,
through the
and then
divorce,
I'll give you
which
10
took
minutes to get everything
1,000
together and
years,
start closing. So we will send the jury right
until
back,
after the
then
divorce.
after we bring them in. So
Well, even though they
let's,
weren't
Ms. Schnock,
divorced.
anything we need to bring
But
up before we
then,
bring the
you
jury?
know,
Your Honor.
over
All
the
right, let's bring the
years,
jury.
my tune changed and we got
Good
to
morning, ladies
figure
and
out how to
gentlemen
be
of the jury.
friends
The
again.
people have rested their case, and now the defendant has an opportunity to present evidence if they so wish to do so. Ms. Schnock, does the defendant have any evidence?
Your Honor, due to the fact that Mr. Jones waived scope objections during his case in chief, our evidence was able
I'll
to
slow it
come
down
in over
for
the
her.
last week of testimony, so we will not be presenting any evidence today, Your Honor.
I really
All right,
wish they
ladies
would have
and gentlemen
turned
of
closed
the jury,
captioning on.
I know this
'cause
sounds
that
a little
helped.
silly, but I'm going to send you back into the jury room because we have a few things we need to take care of prior
this judge
to
is giving
finishing
me a
up
headache.
the trial in this case. I would remind you that you still have not heard the closing arguments of counsel, nor have you been instructed as to the law on this case. So you must not discuss this case with anyone, even amongst yourselves, until it is time to start your deliberations. You are not to reach any opinions or conclusions about the case until you have heard everything. And then I would also remind you that although you are able to use your phones, etc., while you are in the
Oh,
jury
Jayhawks, their other song
room
was
at this
Blue. Oh,
point,
I love
once
that
you
song.
start deliberations, you will not have access to those devices. So at this point, I'm going to send you back to the jury room. It'll probably be 20 to 30 minutes that we need to take care of business, and then you will come back in and start with closing arguments, okay? So if you...
All right.
Okay.
For a directed verdict, but would not go into the detail of the motion, would simply renew it at this point.
Mr. Jones, you wish to be heard in response?
Same argument.
That was
All
the
right,
end of
well,
yesterday. That's
The
typical.
decision on a motion for directed verdict at the close of all evidence is a little bit different than after the motion at the close of the people's evidence, because the motion at the close of all the evidence, the court must make a determination of whether or not there is sufficient evidence for a reasonable jury to find the defendant guilty. And in this case, the people have provided or presented enough evidence on each of the charges in question where a reasonable jury could find the defendant guilty of each of those charges. So that motion would be
Such a
denied.
banner.
And then Mr. Jones, I have been provided with the 2 instructions that were changed. Have you seen those?
I have, Your Honor.
All right.
Your Honor, just for the record, when you say change, the original said not typographical errors, but contained a sentence from the previous instruction on the instruction before, just due to spacing issues. So we corrected those errors.
Correct. Ms. Schnock, any objection to the, well, you probably haven't seen,
I have not seen them.
the new documents. What happened, and if you want to review these, is that the definition of the dwelling place of another contained on the instructions that were to be sent back to the jury contained the first sentence of the next instruction, which was to sustain the charge of the home invasion. And then that instruction, the original instruction, then was incomplete for that next instruction. The people have corrected that. And so now the court has the instructions which contain only one instruction on each page and the whole instruction on each page. So the court is going to accept then those, what we consider clean copies of those instructions. They're
Dawson's
not
Creek.
changed. They're simply
Dole,
printed out in
Shannon.
the proper form.
I'm gonna make you
then,
love me
Mr.
was
Jones,
in
anything we need to
Dawson's
bring up
Creek.
before we break and do closing arguments? Ms. Schnock, anything we need to bring up before we do closing arguments?
No, Your Honor, thank you.
All right, let's break for about 10 minutes so you can each get your stuff ready, and we'll go on to closing arguments. Ladies and gentlemen in the audience, going to advise you again.
Here's the phone.
Security sees you with your cell phone.
Okay, we
The
got
public.
it.
However, if you are media, you need to have.
Okay, we're
let's go to
good.
the jury.
Road bike with no reflector.
Okay,
Mr.
now
Jones,
we're
you
going
may
to
be
finally
heard.
get down to
Thank you, Your
business
Honor.
here.
Police court, vote counsel, ladies and gentlemen of the jury. On February 23rd, 2023,
You know,
rode a bike with no reflector.
you would think, especially for closing arguments, they'd have a microphone somewhere near the guy, or they would put on closed caption. I have very high-powered ears in my ear, in my ears, and I can hardly hear the man.
That he had bought on Facebook. Gentlemen of the jury. On February 23rd, 2023, the defendant rode a bike with no reflectors on it that he had bought on Facebook to Becky Bliefnick's home. He rode that bike past the Quincy Bus Barn and past 224 South 20th Street, just like he did on February 14th, 21st, and 22nd. But on February 23rd, 2023, the defendant climbed up a chair at a pergola and onto Becky's roof. And he walked on her roof and he walked past 4 other windows to the window of a bedroom that he knew was empty. The window of a bedroom of a little boy who at that very moment was asleep in his father's house. And on February 23rd, 2023, the defendant pried open that window with a crowbar, just like he read on the internet. He climbed through that window and he broke down Becky's door and he chased her into a bathroom. Becky fell to the ground and the defendant looked down at her, looked her in the eyes, and shot her 14 times. He shot her with a gun with a homemade silencer that he read about on the internet. And on February 23rd, 2023, after he executed Becky in cold blood and left her there on that bathroom, slowly bleeding to death, surrounded by 8 shell casings, he rode that same bike past the Quincy Bus Barn, just like he did on February 14th, 21st, and 22nd. He went back to his house, where police would later find 27 shell casings that exactly matched the 8 shell casings that were fired by the gun that shot and killed and executed Becky. The 27 shell casings in his house exactly match the shell casings
That's not
that
what
were
the lady said.
around Becky. Not the same type of gun, not the same brand of gun, the exact same gun fired all 37 shell casings.
Okay, I'm sorry. I'm going to pause when he says this stuff because I am a strict believer that you should only charge people with crimes you can prove they committed. You can't give the jury a word salad and misrepresent the facts. The woman said in her testimony, well, for starters, Ian Runkle, if you're watching, I've sent you a couple of tweets now. Even Gisela on True Crime has seen my tweets, but you have not. I understand you're probably busy working, but this is kind of important. I believe during the Murdaugh trial that Ian Runkle in a hotel room with Rob from Law and Lumber well, it might have not been in this specific one. No, that was talking about the two-gun theory. Never mind. But in another circumstance, Ian Runkle, I think, said that because of the manufacturing process of firearms, the matching of a firearm using the marks it leaves on the casing is nowadays kind of junk science, because those firearms are manufactured, like the manufacture of them is so fine-tuned that they basically the same, on the same, that same batch of firearms produced at the same exact time will, I believe he said, leave the exact same markings on the shell casing. So Ian Runkle, if you're listening, could you tell me if I'm right on that or if I'm incorrect and misunderstood? And she said, so there was 54 shell casings on the floor in Tim's basement. There were 8 shell casings around Rebecca's body. Those 8 shell casings, so then 27 of the shell casings were of the 54, so half, exactly half. Coincidence? I don't know. Exactly half were said to match the shell casings found next to Becky's body. When she was cross-examined by Schnack, she said, "Did you compare each of those 8, like number 1 of the 8 to each of the 27?" And she said no, because the 27 were already deemed to be the same. I don't know. Again, I'm just trying to provide some critical thinking and make sure that a man goes to prison for life based on evidence, not based on theory.
Just like identical twins have different fingerprints, each and every gun leaves a different fingerprint on every shell casing it fires. Each and every gun. And every one.
And again, Ian Runkle, if you're listening, isn't that considered junk science?
Of those 35 shell casings had the same fingerprint. They were fired by the exact same gun. Not the same brand of gun, not the same type of...
And I don't know where he's getting 35. There was 54 shell casings. 27 in the testimony yesterday were considered to be fired from the same gun next to the body of Rebecca. Now keep in mind also, that gun was never found. The gun at Tim's house did not match.
gun. The exact same gun fired all 35 of those shell casings.
That they never found.
Now, what the defendant did on February 23rd, 2023, in Adams County is called home invasion and first-degree murder. And after you hear all the arguments, the judge is going to tell you that to prove those things, we have to prove certain elements. To prove home invasion, we have to prove these things on the screen. And usually what I would do in a closing argument is I read each of these propositions to you, and we talk about those propositions. And then I'd read the proposition for first-degree murder, and we talk about those propositions. But this case is different. This case isn't a propositions case. This case is about one question. This is a one proposition case, if you will. And the proposition is this: did the defendant do it? Have we proven beyond a reasonable doubt that the defendant did it? And after you hear the evidence, and after you hear the closing argument, if you believe that you've proven it beyond a reasonable doubt, then you find the defendant guilty. And what happened on February 23rd, 2023, that violent and tragic end to Becky Bliefnick's life? Well, it started on September 18th, 2009, when Becky and the defendant were married. After a few years, in January of 2021, January 21st, the defendant filed for divorce. A few months later, in May of 2021, Becky starts to tell people about her fears that something's not right. She tells Christine Moore, he screamed in my face. He shoved me in front of the kids. He's thrown things across the room where the kids and I were standing. He's punched a hole in the wall. If things really don't go his way, I feel he can be very unstable and unpredictable. And the thought's gone through my mind, if I may need a restraining order, I'm changing the locks as soon as I can.
Pausing again to tell you those are from 2021. So again, name me a divorced person out there that was an extremely hostile towards their soon-to-be ex-husband or wife in the, beginning stages throughout the whole entire divorce process and shortly thereafter. Now, granted, they were never divorced, but
She tells Christine Moore
that's kind of a cheap shot to throw that into closing arguments, in my opinion.
that the only way the defendant has to make sure that the boys choose him over her is to eliminate her as a choice. Then on Mother's Day of May 2021, she tells her friend, Nicole Bateman, Tim told me if I outed his dad that he would probably have to move and then he would kill himself. And yes, I absolutely worry he will try to take the kids sometime, especially if I get awarded the custody I want. He will be pissed, and he will do whatever he feels like doing. In June of 2021, Becky calls out to another friend, to Becky Spots, and she tells Becky, I'm wanting to never have my children around them alone ever again. It's gotten to the point that I hate to even go to work for fear that he will secretly take off with the kids and I won't see them for a long time. Forever. I truly believe Tim has serious mental health problems and he's becoming more vengeful and unpredictable. And it scares me. But I'm scared to even try to get an order of protection because it will piss him off and he will try to punish me somehow. And I don't think an order of protection will be issued because they will say his violent outbursts.
All I keep telling myself in my head is, what of this makes someone a murderer? Where's the evidence that showed he murdered her?
Have not been egregious enough, and the incidents have been stretched out over too long a period. Temporary custody has not even been set yet because we haven't been to court, and I don't have even exclusive possession of our home, so I can't legally keep him away from me or the kids. Plus, if I ask for an order of protection, I won't be able to come see my children in his house anymore, and he may cut off their communication with me while they are there, and that scares me too. And then she tells Becky,
Oh, I
it
see.
is a fucking nightmare.
I see. The 35 is the 27 in the basement plus the 8 around her body. I get it now.
In August of 2021, she gets a court order. She gets a court order that says Ray Bliefnick, the defendant's father, can have no unsupervised contact with the boy. August of 2021. The defendant's required to pay her alimony of $2,100 a month and child support of $472 a month. September of 2021, he sends a message to her sister. If something ever happens to me, please make sure the number one person of interest is Tim, as that is who would do something to me. I'm putting this in writing that I'm fearful he will somehow harm me, come after me, or will try to do something to me that takes me away from the kids, or the kids away from me. He already has lied multiple times to paint himself as a victim and me as the perpetrator when it is the other way around. No, I have not said this to Mom or Dad, as I don't want them to be out of their mind with words. And just 4 days later, she messages her friend Nicole Bateman again. A friend of mine from the ER was murdered last Friday by her ex. I literally had a panic attack Friday night thinking Tim is going to come after me and do the same if he continues to not get his way. If he's crazy enough to file this OOP and make all this crap up and blame it on me, what else is he willing to do? On top of the fact that he has all our guns and ammunition, including mine. And in October of 2021, he learned on...
Remember, this is,
October 15th,
he's talking October,
defendant
stop a
cell phone
second.
was factory reset.
He's talking October 2021. Now, another thing is, I know that, I thought it was a 22, but then I thought I heard it was a 9mm. So the question is, was there ever an inventory of the guns that were registered to Tim and Becky? I know she was trying to get the one back in the divorce settlement, which was never returned. But how are you supposed to return a gun when you can't get within 3 feet of each other's car? You're supposed to just chuck the gun out the window? And he did try to, speak to some law enforcement to try to do a, exchange, get it on the record that it was going to get back to her and probably work something out. Please don't hate me. I'm just trying to make sure that Lady Justice is blind.
So when the defense says, well, we don't know how old those searches were on his phone that we'll talk about, remember, his phone was factory reset on October 15th. Then on October 22nd, Becky gets another court order. This time, it's an order of injunction. Neither party shall go to the other party's residence except for the exchange of the minor children. I bring this up for this reason and this reason alone. It's perhaps possible that some of you are thinking, well, the defendant had a right to be at Becky's house still, so he can't commit home invasion because he had a right to be there. No, he did not. There was a court order.
It's been established that the
"Thou
kids
shalt
were
not,"
at his
and
house
the defendant was told
at the time she was
not to
murdered.
be
She
there.
just had surgery.
He did not have a right to be at that house. That house on Kentucky Street, at that point, and until the divorce was settled, was Becky.
And he had also text messaged her, I don't know if it was the 21st or the 22nd, that he wasn't feeling good, asking if, even though he was supposed to have the kids, if she could have the kids instead. And to which she, amicably replied, not F you. She's like, oh, sure. I don't remember what the exact exchange was.
Becky's and Becky's alone. And in October 22nd of 2021, the defendant was ordered to give Becky
October 2021.
75, and if he couldn't, he was ordered to give her a Ruger LCS.
I'm so sorry. I have to. Again, if the state's evidence is so strong, why is he wasting his time on so much that was so many years ahead of this? I mean, bring it up, yes, but he's just hammering it.
Now, when he didn't give her that gun, Becky called the police. And the police went and talked to the defendant, and the defendant said, I don't know where the CZ is. And the police told Becky that, and Becky said, then I want to report the gun stolen because the defendant stole it. He hasn't given it back to me. He hasn't. Late fall, early winter of 2021, Becky cries out to another friend. She tells Amber Whitler, if anything ever happens to me, it was the defendant. And in March of 2022, she cries out to a friend in California. And she tells Christine Mendel, I feel safe
Gotta be
right
good at
now,
reading lips, people.
but I'm super nervous for when this ends. If he doesn't get his way, he
2021.
might literally lose his mind. Because she got a security system, that the defendant wants everything. He wants sole custody of the kids. He wants all the money, all the assets.
Oh,
He
sorry,
wants
March
me
2020. My bad. 1 year
to suffer.
before.
But I've had some serious PTSD with all this and the things I found out. Plus, I've had not one but two coworkers get murdered by their exes in the last year, which has totally made me.
That's justified. I would be too.
I'd rather let him believe what he tells me and stay alive for my kids. It sounds so crazy to say that out loud, but it's not out of the realm of possibility that he would go off the deep end. He literally cares more about hurting me than anything else.
That's
I
understandable.
literally would never trust him to ever let him in my house if it was just us. Then in June of 2022, she calls Gary Collins on the phone. She's crying. She's emotional. She's in tears. She tells Gary Collins, who was a police officer at the time, if anything happens to me, it was the defendant.
I'm pretty sure she said it was Tim, not the defendant.
August of 2022,
That's
Becky gets another court order. Neither party shall go to the other party's residence except for the
this
exchange
is
of minor
August
children.
22nd, 2022.
I bring that up. Well, just
Order entered October 22nd, 2021.
to be at that house in Kentucky Street. And in October of 2022, John Smith receives notification about Mike Blazing's bike being sold. I want to talk about this for just a minute. The defense might suggest that we don't know who John Smith was. And I guess my response to that would be this. If we're sitting here in the courtroom and we hear thunder outside and we see a flash of lightning, and somebody walks through that door, and they're wearing galoshes, and they've got an umbrella in their hand. Do you have to look out the window to know that it's raining?
Okay,
No,
Matlock.
you don't. Do we know who John Smith was? Yeah. John Smith sits right there. John Smith drove an orange rust CRV. That was the message that he sent. The defendant drives that same CRV. John Smith says that he's got long brown hair. The defendant had long brown hair. John Smith bought a black mongoose bike. There was a black mongoose bike in the defendant's garage. And John Smith got notifications on his phone about a blue bike with no reflectors that was sold by Mike Blazing to a tall, athletically built man. Do we have to look outside to know if it's raining? We know who John Smith is, and we know what John Smith did. December 2022, just 3 months before Becky was executed in cold blood. Becky files her pretrial affidavit. And in Becky's pretrial affidavit, she talks about that CZ-75 again, because she didn't have it. There was no gun safe in her house. There was no ammunition found in her house. We've heard no evidence of that. She didn't have a gun. She wanted that gun back, and if the defendant didn't give her that CZ-75, he was supposed to give her a Ruger 9 LCS. We'll talk about that Ruger LCS in a minute. And in Becky's proposed parenting plan, talking about custody of the boys, Becky agreed to 50-50. Becky agreed to a fair split, 50-50 between her and the defendant. Compare that to the defendant's proposed parenting plan. When he filed the proposed parenting plan in December, he wanted 70-30 his way. She would have 4 overnights in a 14-day period. That's what the defendant wanted. Then in January of 2023, the defendant sends a letter to Becky about what he wanted. And what did he say? He said, well, I'll go 60-40. And I'll do 50-50 if you get a psychological evaluation. And he said, I'm not going to pay any child support. I'm only going to pay maintenance of $750. And you know that house that you've been living in with those boys for the 2 years? That's mine now. You get 60 days to find a new place to live. And my father, even though there's been a court order for 2 years that there's no unsupervised contact, my father can see the boys whenever he wants, supervised or unsupervised. That's what I want. That's what the defendant said he wanted in January of 2022. And now January 5th of 2023, I apologize, January of 2023. January 5th of 2023, Becky calls out again to a friend, Melissa Young. A friend she hadn't seen in a while. And what does her friend say? Her friend says, Becky looked emotionally drained and tired. And Becky said, the defendant told her, you'll be dead before you get my money. And Becky asked for prayers. Sometime in January, Becky calls out to her friend Sarah Murphy and says, if anything happens to me, you better go looking for the defendant. And the defendant told me, I'm tired of playing your stupid little game. And in January of 2023, weeks before Becky was left alone on that cold bathroom floor, the defendant's asking his next door neighbor, do you have any cameras that can see into my backyard? February of 2023, the month that Becky was killed. On Friday, February 10th, the defendant calls the Quincy Police Department and says that he's going through a brutal and contentious divorce. And he says, I've got to give a gun back to that crazy bitch. And he says, Hall of Fame QU football player, active in CrossFit, says, I don't feel safe around her. Let's focus on these 3 weeks. And let's start with February 13th and 14th of 2023. On February 13th, 2023, at 2:02 p.m., we know that that's the last time there was activity on the defendant's computer, last time there was any internet search on his computer, 2:02 p.m. until 1:10 a.m. And we'll talk about that in a minute. And we know that at 7:38 p.m., it's the last call on his phone until 1:32 a.m., and we'll talk about that in a minute. At 11:44 p.m., Ted Johnson, Becky's boyfriend, texts her, "I'm on my way." And we know that he arrived at the house at around midnight the next day, the 14th. And we also know that he parks his truck with that license plate and that VIN number on the back parking lot, back driveway of Becky's house. And we also know that on February 14th, at midnight, the defendant's Whoop armband loses connection. And what happens after that? What happens after his Whoop armband loses connection? For the first time, we see this video at the Quincy Bus Barn. A bike with no reflectors, just like was on John Smith's phone. And what happens just a minute and a half after that? Well, at 12:31 a.m., we see this video at 224 South 20th Street. And just 6 minutes after that, we see this video at Taylor Hyman's house. And what do you suppose we're going to see about 15 minutes later? This video back at the Quincy Bus Barn. Person on a bike with no reflectors. And is it a person on a bike with no reflectors, or is it the defendant on that bike? Well, right after we see that video, the defendant's Whoop mysteriously reconnects. And right after we see that video, and right after his Whoop mysteriously reconnects, and remember, while all this is going on, this is 1:10 in the morning, Ted Johnson, at that very moment, his truck with that license plate and that VIN number are parked right behind Becky's house. What happens? The defendant goes down the rabbit hole. At 1:10 a.m., 1:10 a.m. in the morning, he starts searching all these things. At 1:10 in the morning, right after his Whoop reconnects. And he's not just searching for license plates. There's a specific license plate that he's searching for. He's looking for ADC J55. Now, how else does he see it unless he's in her backyard? And how else does he see it in his backyard unless he gets there? And how did he get there? He rode that bike. And how do we know he rode that bike? Because his Whoop wasn't connected when he was doing it. But if that's not enough, he looked up, how do I find the owner of a license plate in Missouri? And what does he do right after that? That's at 1:31 a.m. What does he do at 1:32 a.m.? He makes a cell phone call. Who does he call? The Missouri Department of Revenue at 1:32 in the morning. And if that's not enough, he's looking for a specific VIN number. I mean, maybe it's one thing to get a license plate number, but you gotta want that VIN number. The same VIN number that was on Ted's truck that was parked right there, right where the defendant saw it after he rode a bike there, got caught on those two videos, and he got caught on Taylor Hyman's video.
Okay. Again, devil's advocate here. Please don't hate me. But when you have kids under the age of 12 and your future ex-spouse is dating someone else, I didn't, because I didn't care. But I gotta believe that some people do a little investigating on their own to make sure that their future ex-spouses, dating partners aren't, pedophiles or what have you. I just wanted to point out that observation. I am in the minority, I understand, but Lady Justice is blind, remember.
He kept searching until 1:48 in the morning. Over 200 searches, over 38 minutes. Becky said if he didn't get his way, he might start
I am
to literally
being.
lose his mind. He started to lose his mind. Because he wasn't done. A day later, he's still searching. He's still down that rabbit hole. And on the 15th of February, there's a court order. The matter set for trial. The end is in sight for Becky. She's going to testify about all those issues, about the hidden assets, the $500,000 in hidden assets, about the custody of the boys, is it going to be 50-50, or is the defendant going to get what he wants, 60-40, 70-30? That's going to be settled. Is she going to get kicked out of the home like the defendant wants? Is he going to have to pay her alimony or not? He didn't want to pay her the alimony that she was requesting. And what about the defendant's dad? Was he going to be around those boys unsupervised or not? That was all coming to a head. She had her witnesses subpoenaed. They were there. They were going to testify on March 3rd at 1 p.m. It's in the order. All the presenting matters were going to be heard. The end was in sight. And what did Becky say? She was super nervous for when this ends. Because if the defendant didn't get his way, he might lose his mind. February 17th, the defendant's interviewed by the GAL. Rick Zimmerman, what did he tell us? The defendant didn't want 50-50. He wanted 60-40, at least 60-40. Becky was reluctant, but would go along with 50-50. She felt like that was best for the kids. Defendant, no, I want more. I want to win. On the 19th, Becky goes out for surgery. She's at the home of Brandon and Celia Gervais. We heard from them. And she doesn't come back until the 21st, but in between, the GAL report was filed. And what did the GAL say? Well, the GAL said 50-50. GAL said, defendant, you're not going to get what you want. I think it should stay the same 50.
Sorry, I'm trying to keep this off because I got the fan on. I did turn the air conditioner off, so it's a lot quieter in here. But he was seeking 60-40. She was seeking 50-50. And the GAL, which is the guardian ad litem, I think is how it's pronounced, attorney, he's the attorney that's in the best interest of the kids, said 50-50. Do you really think he would murder her over, 60-40 turning into 50-50? Again, I'm playing devil's advocate. I'm asking someone to show me the evidence that he murdered her. He murdered her. He didn't hire someone to murder her or conspire with someone to murder her. He murdered her. That's why I'm looking for the evidence. Again, if the state would have had charges of conspiracy, I might have bitten on that because some of his whereabouts and etc. are, put him potentially in the vicinity. But there's no concrete evidence.
50-50, like Becky had agreed to, and like Becky had filed in her parenting clinic. February 20th to 21st of 2023. Remember, at this point, Becky is still with the Gervais in St. Peter, in St. Louis, Missouri. And at 12:44, on the 20th, the defendant's cell phone locks. And just a minute later, his Whoop, again, mysteriously loses connection. And right after that, we see a video at the Quincy bus barn. Person on a bike with no reflector. And just a minute and a half after.
Now, this is inquisitive because now I can't remember which of the bikes. So there was two bikes. There was one bike that Tim did buy off of Facebook Marketplace. I believe it was a Mongoose, which is kind of looks in my eye like a BMX bike, like an adult BMX bike. The other bike they talk about was a Schwinn, which is a mountain bike. And I think it was the Schwinn that did not have the reflector on the front or the back of the bike. But the Schwinn, I believe it was the Schwinn, was found at a neighbor's house. The mongoose was found in his basement, I believe. Again, show me where he bought the bike directly. Show me what the name of the neighbor was that the bike was parked in for up to 4 days.
After that, you see a video.
And they can't tell by the video who's riding the bike.
That's 224 South 20th Street. And 15 minutes later after that, you see a video at the bus barn. Person on the bike with no reflectors, headed north this time. And after the bus barn video, about 25 minutes later, you see another video at the bus barn. Someone on a bike with no reflectors. Defendant's whoop. Still not connected. No activity on his laptop, no activity on his phone, not one text, not one phone call. And 15 minutes after that, person on a bike with no reflectors. You might be asking yourselves, well, why is there no video at Taylor Hyman's house? I would remind you, Becky wasn't there that night. Becky wasn't at home that night. But mysteriously enough, at 2:11, defendant's armband, after we see the person on the bike, reconnects, and his cell phone unlocks. Becky gets home on the 21st at 11:30 that day. I'm sorry, 11:03 that day. Let's go into February 21st and 2022. And again, let's remember, no activity on the laptop from 8:27 p.m. to 7:01 on the 22nd. No calls on his cell phone between 4:37 on the 21st and 9:29 a.m. on the 22nd. 7:46, Becky texts the defendant and says, will you watch the kids the next day? We saw those messages on Our Family Wizards. And at 8 o'clock, Ted Johnson, Becky's boyfriend, brings her kudo. He's there for about an hour and a half. And at 9:30, Ted helps Becky get into bed.
He testified he was there for about an hour. And he got there around midnight, left around 5 a.m. Did we ever get Ted Jones' information? Just asking a question here.
Kisses her on the forehead and says goodnight.
I want to hear that
Last
again.
time, Ted Johnson
He said an hour and a half. That's not
Becky into
true.
bed, kisses her on the forehead, brings her kudo. He's there for about an hour and a half. And at 9:30, Ted
Oh, he
helps
said he was
Becky
there an
into bed,
hour.
Kisses her on the forehead and says goodnight. It's the last time Ted Johnson ever saw her alive.
Or so he says. Whoop.
At 12:42, the defendant's whoop loses connection. What do you think is going to happen next? If you guessed that his cell phone locked, you got it right. What do you think happens next? If you guessed, will there be a video from the Quincy bus barn? You got it right. 12:57. And what happens next? If you guessed, video at South 20th Street at 224? You got it right. At South 20th Street at 224? You got it right. Headed north on 20th Street, I'm sorry, south on 20th Street, turning east on Prairie towards Becky's house. And what do you think happens after that? About 5 minutes after that. If you said, I wonder if there'll be video at the Hyman residence. There was, at 1:05 a.m. And what happens about 15 minutes after that? (1:10 a.m.) Quincy bus stop. Person on a bike with no reflectors, headed west, away from the direction of Becky's house, towards the direction of the defendant's house. What's going to happen next? If you guessed that his cell phone would unlock and the defendant's whoop would mysteriously reconnect just 6 minutes after we saw that person on the bike, you got it right. And then at 1:39, his cell phone locks again, and his whoop loses connection again.
Okay, keep in mind, they're talking about the night before. So what are they implying? That it was like a dry run?
There's a video at the Quincy bus barn of a person riding a bike with no reflectors. South on 20. And a minute and a half later, there's video at South 20th Street, 224 South 20th Street, of a person riding a bike, south on 20th Street, and once again, turning east on Prairie.
They have the dates. I think they have the dates wrong.
In 15 minutes, is there going to be video at the Taylor Hyman residence of a person?
Because she was murdered in the early morning hours of the 23rd.
And if you're asking yourself, well, after that, is there going to be video at the bus barn again of a person on a bike with no reflectors headed north on 20th Street, away from the direction of Becky's house and towards the direction of the defendant's house? Yep, you got that one right, too. Is it 206? There we go. And if you're asking yourself, well, how do you know that's the defendant?
The dates are wrong.
Once again,
See on the top here, it says February 21st, 22nd.
right after you see
And the
person
stuff
on
that
the
I'm
bike,
reading from the
reconnect,
testimony
and his
yesterday,
phone
February
unlocked.
22nd.
14th, 20th.
She was murdered in the early morning hours of the 23rd.
And on the days where we don't see the person on the bike, where we don't see, you know what, not a person, the days when we don't see the defendant on a bike, his whoop's fine. It's not losing connection then. The only time we see those losses, those times when the whoop isn't connected, those gaps, are when he's on a bike and he's headed to Becky's house. February 23rd, 2023 hit. Day Becky was murdered. On the 22nd, at 1:15, Kelly Leapley goes to the defendant's house.
Sorry, I don't
She
need to have
stays
you
there
hear me eating licorice, then I
about half
apologize.
an hour. They have sex, and she leaves around 1:45 or 2 o'clock. Now, I understand that Kelly didn't like talking about that, and I understand. It's embarrassing to talk about those things, and I wouldn't bring it up if it wasn't important. It's not important right now. It will be important in about 10 minutes. So bear with me. Just remember, at 1:45, 2 o'clock on the 22nd, the day before Becky was murdered, and when the defendant had to pick up his boys, at 1:45, 2 o'clock, he's not picking up his boys, he's having sex with Kelly Leapley. February 22nd into the 23rd. 8:15 on the 22nd to 6:02 on the 23rd, no activity on his laptop. No calls on his phone between 12:32 p.m. on the 22nd and 8:01 on the 23rd. No activity on his laptop, no calls on his phone. At 7:16, Ted texts Becky. And we saw those text messages. And at 9:47, he calls Becky, and they talk for about 26 minutes. And at 12:36, the defendant's woo loses connection. And at 12:38, his cell phone locks. 12:53, Becky's on Facebook. And at 12:55, we see a video again of the defendant riding that blue bike with no reflectors down 20th Street towards Becky's house.
Isn't it plausible that the guy that's on his bike in the middle of the night, that's just like his normal thing? Because why would a guy ride his bike 2 nights in a row at practically the same time?
You see the video at 224 South 20th Street of the defendant riding that same blue bike that he bought on Facebook and headed south on 20th and turning east on Prairie towards Becky's home. He goes to Becky's house, climbs up that chair, he climbs onto the pergola, and he climbs onto the roof. And he goes past these windows.
Hi, Gabby Rios,
He
59.
goes past these windows, and he goes to this window, the window that he knows goes to a bedroom that's empty, because the little boy who sleeps in that room is asleep at his house at that moment. The random burglar just got that lucky. The random burglar went past 4 other entry points, get to an entry point all the way across on the other side. He pries open that window, crawls through the window. Becky hears the noise. He tries to slam her door shut. The defendant kicks in that door, breaks in that door. And Becky's trying to dial 91126, and the phone falls out of her hand because he breaks in that door, knocking the phone out of her hand, and it's found right there. And Becky runs into the bathroom, and she turns around, and she falls to the ground, and the defendant looks down at her, and she looks up at him, and he points the gun down at her, and he pulls the trigger again, and again, and again, and again. He leaves her like that. And at 1:12 a.m. he runs away. And while Becky is still in that dark, cold bathroom, completely alone, she can't move from the waist down because her spinal cord's been hit. She can't breathe because one of her lungs has been punctured. She's bleeding internally for minutes as she slowly and agonizingly bleeds to death. While that's going on, she's surrounded by evidence of the crime. She's surrounded by pieces of the plastic bag that the defendant used in an attempt to make a homemade silencer, in an attempt to try to catch those shell casings that are projected from the gun. And the defendant's DNA is under the fingernails of her left hand, the same hand that she used to wear a wedding ring on when she promised to love and honor the defendant. That hand was no protection from the bullets that he fired at her. Surrounded by the 8 shell casings that exactly matched the shell casings that were at the defendant's house. Not the same type of gun, not the same type of ammunition, not the same brand of gun, the exact same fingerprint on all those shell casings and all those shell casings in his basement. And while Becky is slowly dying, the defendant is riding that blue bike with no reflectors, furiously home, pedaling furiously away from what he just did, running away from facing what he did. And after he got rid of the gun, the clothes, and the evidence of his crime, or almost all the evidence of his crime, his whoop reconnects, and his cell phone unlocks. The defendant didn't commit the perfect crime, but his mistakes kept going into that morning. On the morning of the 23rd, between 7:30 and 9:30 a.m., Amy Schmiedeskamp told me that she saw the defendant bring a little type-suit over to his father's house. Now remember, the defendant's father, had no unsupervised contact with those boys for over 2 years. They hadn't been over there. Amy Schmiedeskamp said she hadn't seen the boys over there for 2 years. Why does he bring a little type-suit over there unless he knows that that's not going to be a problem for him anymore? Unless he knows what nobody else knows at that point, that at 7:30 in the morning, Becky's body is still less than a block away from where he's dropping off that little type suit. Because he knows Becky's not going to be around to put up a fight now. I'm going to get what I want. My dad's going to be able to have unsupervised contact because Becky's dead because I killed her. Is Amy Schmiedeskamp lying about what she saw? And at 11:51 a.m., the defendant calls St. Peter's School and says, don't let the boys walk home. I'm going to be there to pick them up. Don't let them walk home. Roberta Hudson, the school secretary, said that was unusual, that he had never done that before. Well, what was different on the 23rd? Why didn't he want the boys to walk home? Could it be because he knew that the evidence of his crime was waiting to be discovered and he didn't want his boys to walk in and see their mother shot 14 times on the bathroom floor? He gets to St. Peter's School an hour early to pick up the boys, and Roberta Hudson said that was unusual. There were no other parents waiting that early. And I would remind you, the day before when he was picking up the boys, what was he doing at 1:47? He wasn't getting to school that early. He was doing something else. So what's different about the 23rd?
Okay, the man was having an
What's different
afternoon
is he didn't
delight.
want those boys walking home, walking into that house, and seeing what he did. Also, remember, he called the school. We'll come back to that in just a minute. At 2:47, he picks up the boys, and only after he picks up the boys, only after he picks them up, and he's sure that it's not going to be an issue, only after that does he text Becky's dad and now says, you know what, now I'm really concerned. I wasn't concerned at 11:51. I didn't text you then. I wasn't concerned at 1:47 when I was sitting in the parking lot for an hour. Didn't text you then to say, hey, maybe check on Becky, because I'm here at the parking lot an hour early. Didn't do that then. He waited until the boys were with him. Then he texts Becky's dad. And when Becky's dad tries to call him, just 3 minutes later, he doesn't answer. Because he wants somebody, he needs somebody to go into the house now. He needs somebody to find her body. At 3:30, Becky's father does just that. And when the defendant finally does call that phone back at 4:14, what does he do? He lies. He tells Becky's mom, the school called me that Becky wasn't there, so I came to the school to pick up the boys. That's not what happened. Why did he lie? Is Rolla making that up? No, Rolla told us exactly what she heard. She said, the defendant said on the phone, the school called me, and I only went to the school because the school said Becky wasn't there. That's not what happened. We know he called the school. Why did he lie? And on the 27th,
I don't think that's what she
just
said.
4 days after Becky was brutally executed, we find a bicycle. Not down by the river, not on the east end of town, not on the north end of town, not on the south end of town, not 6 blocks away from the defendant's house, not 4 blocks, not 3 blocks, not 2 blocks, not even a block away, half a block away from the defendant's residence, we find that blue bicycle with no reflector. And we know that's important because on the left we saw Kelby's ride, Zach Demas's ride, where he rode that bike with reflectors on it. We saw those reflectors light up, and we didn't see that on the 14th, the 21st, the 22nd, or the 23rd. That's how we know. That's the bike. The defense will say, well, DNA is not on it. Okay, fair enough. That bike was outside for 4 days. We don't know what happened to it in those 4 days. We don't know who else touched it. We don't. But what we do know is that that's the bike the defendant was riding because he got it off Facebook. It was on his phone under a John Smith burner account, just like he bought that black Mongoose bike that was in his garage. They were set at the same height, less than a centimeter apart.
Okay, this guy is really ticking me off. What's the average height in the United States for a male? Number 1. Number 2. outside of maybe when you first get your bike, how many times do you adjust the seat? I don't think any of my bikes have changed. And my son, who grew like a weed from the time he got his bike, he would ride his bike. And at one time I caught him I would take the bike down and pump up the tires for him. And then off he would go. He loved to ride his bike. But, you know, he went from my height to over 6 feet in a couple summers. And one time he comes back, "Hey, Mom." And like his knees are basically hitting the handlebars. But I'm just saying, what is the average height of a U.S. male? Hey Siri. What is the average height of a U.S. male?
Here's an answer from Healthline.
5'9".
The average American man is about 5'9".
Okay, so what is the seat height for a man that's around 5'9"? And if you were 5'8", 5'9", 5'10", 5'11", 5'12", or 6 feet, you know, what's the likelihood that you're going to actually have your seat at the right, you know, like when you go buy your bike at Eric the Bike Man and they adjust your seat for you? Just saying. Show me the concrete evidence.
March 1st,
And don't
we searched the
hate me.
defendant's house, and what do we find? We find in his bedroom an empty gun safe. An empty gun safe. Where's the gun? We know that there was purchase history for an SR9, Ruger SR9, that the defendant bought. We didn't find that when we searched. We know that Becky wanted a CZ75. Didn't find that when we searched. In fact, the only gun we found was that Ruger LCS that he was supposed to give to Becky, and he never did. And where did we find it? We found it downstairs in a gun safe. If you're going to use a gun for personal protection, and you have a quick access gun safe, you store the gun there.
Sorry, I thought I shut it off. Again, did we get a thorough record of what guns were registered to Tim and Rebecca Bliefnick? And if so, were any of those guns missing?
But he didn't. The handgun for personal protection was downstairs, and a lock safe downstairs, and not in.
They had little kids in the house.
Gun
That's
safe.
pretty typical that you keep them locked in your gun safe.
Bike. And in his house, we also found all the garbage bags, all the grocery bags, and that crowbar. And a lock safe downstairs, and not in the empty, interestingly enough, gun safe in his bedroom. We talked about the Black Mongoose bike, and in his house, we also found all the garbage bags, all the grocery bags, and that crowbar, and those shell casings. Again, remember, all around Becky's body were pieces.
Okay, that is weird that you wouldn't keep your gun in your gun safe, but also, I'm not going to tell you exactly what I have in my room, but like, I'm not going to freaking mess around with a gun safe or anything, and my kids are all 16 and over. So, times have changed. But his kids were 12 and under. Also, now he's going to talk about an Aldi bag, which again, the evidence, the guy's testimony was like, yeah, this is pretty generic. And we didn't find any evidence. He keeps bringing up things that are not concrete, and it's really getting on my nerves.
A plastic bag, pieces of a plastic bag that the Illinois State Police Crime Lab, to be fair, they said it was inconclusive, but I'm not a scientist. All they can say is that that's inconclusive but consistent. Okay. Guess maybe it's good that I'm not a scientist, because that's a match. And the tool marks that were left on that window that the crime lab analyzed with this pry bar. And what did they say about the tool marks and the pry bar, the crowbar? There were microscopic consistencies between the two of them. She had to call it inconclusive because she couldn't exactly replicate the manner that tool marks were made, but there were microscopic consistencies. It was inconclusive, but consistent. Just like That is inconclusive, but consistent. And remember, on those pieces of plastic bag, there was DNA. And Ted Johnson, in case you're thinking, well, maybe Ted Johnson had something to do with it, Ted Johnson was excluded. In fact, Ted Johnson's DNA wasn't found in the house. It wasn't there. But the defendant couldn't be excluded. In fact, it was 8 times more likely that it was his DNA on that piece of plastic than 2 unrelated individuals. 8 times. And under Becky's fingernails of that left hand, 3 times more likely it was the defendant or one of the boys. But also remember, she hadn't been around the boys since she left for surgery on the 19th. She had to scrub in for surgery. You have to clean yourself off for surgery. So, boys' DNA under fingernails?
Couldn't that be evidence that maybe the evidence lab was contaminated? I mean, I get that. She hadn't been around her boys for days. So then why was the DNA found underneath her nails more similar to the boys than anybody? That doesn't make any sense at all. Plus, she'd had surgery. So her fingernails were, scrubby-dub-dubbed.
Defendant's
Oops, sorry.
under her fingernails. And the shell casing. The 8 shell casings that were around Becky's body and the 27 shell casings that we found in his basement. And the exact match. Defense may say, well, we don't have any fingerprints. Yeah, we do. These are the fingerprints. The same gun fired all those bullets. Not the same brand, not the same model, the exact same gun fired every one of those bullets. The defense may say, this case is circumstantial. And you may be thinking in your mind, well, it's a circumstantial case. But the key word in circumstantial evidence isn't circumstantial, it's evidence. Circumstantial evidence is evidence. It's proof of facts or circumstances which give rise to a reasonable inference of other facts which tend to show the guilt or the innocence of the defendant. Let me put it to you like this. There's an old game show that I used to watch. I don't know if it's on anymore. You spin the wheel and you pick letters. I think it's called Wheel of Fortune. I don't know if it's still on. But let's play Wheel of Fortune. Are you convinced beyond a reasonable doubt that says happy birthday? Well, each letter is another piece of the puzzle that you use to solve it. And just like you don't have to have every letter to be convinced beyond a reasonable doubt that that says happy birthday, you don't have to have every piece of the puzzle. You don't have to have the gun to convict him of murder. You don't have to have a confession to convict someone of murder. You don't have to have an eyewitness to convict someone of murder. Those are nice letters to have, but you can solve it without it. So let's take a few minutes to go through the circumstantial evidence in this case. Sarah Riley, Sarah Murphy, Melissa Young, Nicole Bateman, Christine Moore, Amber Whitler, Christine Mandel, Becky Spots, Gary Collins. All these people told us the same thing. I'm not going to go through all their statements again. All these people told us that Becky was scared of the defendant, that she thought he was going to do something to her, and that she thought if anything ever happened to her, it'd be the defendant that did it. Every one of them. They didn't say it was somebody else. They didn't say it was Ted Johnson. They didn't say she's scared of a random prowler. They said she's scared of the defendant. Every one of them. And frankly, does it matter how long ago she said it? She was scared for 2 years. And she had every reason to be scared for those 2 years. What about motive? Well, we know that the defendant's father could have no contact with the kids, and we know the defendant didn't like that. Child custody, we know the defendant didn't want 50-50. He wanted 60-40, 70-30. Maintenance, alimony, we know they disagreed about that. In his letter just a month before she was murdered, I'll pay you $750. We saw the calculations that they filed. Becky thought she should get at least twice that. The child support, he didn't want to pay any child support. And the hidden assets. We heard from Becky's attorney that she thought there were almost $500,000 in hidden assets. And we do know that the defendant told Becky, according to one of her friends, you'll be dead before you get my money. The missing CZ-75, they didn't agree about that. The marital home, the defendant wanted to kick her out of the place that she had lived with her 3 boys for the 2 years since he had moved out and filed for divorce. He wanted to kick her out. You got 60 days to find a new place to live. And we know that the divorce hearing date was coming up. In fact, just a week after she was murdered was when it was scheduled to start. The witnesses were subpoenaed. Becky was going to testify. It was all lined up. It was in an order. It was ready to go. But we never got to have that hearing. We never got to have her day in court. And who benefits from that? In the entire world, who benefited from not having to have that divorce hearing? One person. He sits right there. The GAL report. GAL said 50-50. Wasn't what the defendant wanted. He thought he was going to lose. And what did Becky say? If he doesn't get his way, he might literally lose his mind. The witnesses were subpoenaed. She was going to testify. It was all set up. But in January, the defendant asked Bradley Eman about those cameras in his backyard. The defendant was thinking then, how am I going to get away with this? February 10th, he calls her a crazy bitch and says he's scared of her. And when we search his house, we can't find that Ruger SR9 that we know that he bought. It's also a 9mm. February 14th, he goes down the rabbit hole of the Ted Johnson searches. He starts to become more and more unhinged. He's looking for that license plate that at that exact time was parked in Becky's driveway. He looks for that exact VIN number. He calls the Department of Revenue at 1:32 in the morning. I ask you, are those the actions of someone who's stable? We have the video on the bus barn and how that correlates with everything. We have the video from 224 South 20th Street. We have the video from the Hyman house. But not just that, we know that after Becky's murder, there were no more midnight bike rides with a bike with no reflectors. And we know that after Becky's murder, there were no more midnight bike rides at 224 South 20th Street. And Taylor Hyman said after Becky's murder, there were no more issues in the driveway there either. The John Smith Facebook account, we've talked about that. Mike Blazing, he sold that blue bike to a tall, athletic white man. John Smith, who we all agree is the defendant, it was on his phone. We saw the messages where John Smith described himself. No reflectors on that bike. The bike was found less than half a block from the defendant's house. The bike height seat was almost exactly the same, less than half a centimeter away from the bike that we found in the defendant's garage, that he also bought on Facebook. These rides occurred in the middle of the night in February. And is there any other motive to kill Becky? This wasn't a sexual assault. This wasn't a burglary. Nothing was missing. Her purse was there. Her credit cards were there. Her laptop was there. Her checkbook was there. Nothing was missing. Random burglar breaks into the house and doesn't steal anything. The next morning, the little tyke soup. He's delivering a little tyke soup to his father when nobody knows that Becky's dead except for the person that killed her. He calls St. Peter's at 11:51 when nobody knows that Becky's dead except for the person that killed her. He arrives an hour later when nobody knows that Becky's dead except for the person that killed her. And that's important because the day before,
I think he called the school early because he had sent her the message saying that he wasn't feeling good and asking if there could be a change in the schedule. And she acknowledged, sure. I'm just speculating. I already see I've lost a follower. That's unfortunate because I'd like to have some open debate and not just people get mad and storm off.
before when he was picking up the boys, he wasn't there an hour early. He was doing something else. He texts her dad, not at 11:51, not at 1:47 when he's sitting in his car alone for an hour waiting for the boys, not until after he picks up the boys. And then, after he texts Becky's dad, he lies to her mom. The manner of entry, it was climbing up that wall. It wasn't done by a non-athletic person. It's an athletic means of entry, and the defendant is athletic. He was involved in CrossFit. He was a former QU football player, Hall of Fame player, in fact. The path of entry, does it point to anyone else? It points to someone who knows who's in that house and who's not in that house. They go past 4 other points of entry, past 4 other windows, and goes into the first window But they know nobody's there because the little boy who slept in that room was sleeping in his house at that exact time. Then they chase Becky down. A random burglar breaks into the house, finds a gun, I guess, or brings a gun that somehow had shell casings in the defendant's house. I'll talk about that later. Finds that gun, or brings it, breaks in, then chases Becky down, kicks in the door, and then stands over her and pulls the trigger 14 times? A random prowler does that? It's a crime of passion. That's somebody who's mad. That's somebody who wants that person dead. It's not just a murder, that's an execution. The tool marks on the window, the crowbar in his home. Inconclusive, but consistent, microscopic consistencies. The Aldi bag pieces and the Aldi bags in his home. Consistent. I'll show you the picture again, but you know. And all those Aldi bag pieces, the defendant's DNA, not Ted Johnson, not somebody else, the defendant's DNA, 8 times more likely. And underneath her fingernails, the defendant's DNA, 3 times more likely.
I don't remember that testimony.
The empty handgun safe in his house. And there's no handgun safe at Becky's house. Assume for a moment that it's a random prowler. Does he get the gun from Becky's house? Becky doesn't have a gun. She's been asking for a gun for 2 years. She wants her gun back. She never gets it back. She didn't even have a handgun safe. Ammunition, nothing. And of course, we don't know where that CZ-75 was, and we don't know where the Ruger is that the defendant bought. The 8 shell casings at the scene and the 27 shell casings in his basement, all fired by the exact same gun. Again, I hate to say it again, but not the same brand of gun, not the same type of gun. The same gun fired every one of those 35 shots. Those 35 shell casings were fired by the
Same gun that was never found.
The gun that killed Becky fired the shell casings in the defendant's house. And of course, we know that there was no laptop activity on his laptop at these times when we see these bike rides. And there was no cell phone activity at the time that we see these bike rides. And that his cell phone was locked every time we see these bike rides. And that the Whoop data all shows that his Whoop was disconnected every time we see this bike ride. Every time. All it would take is one phone call, one text message, one you up, one how you doing, one Google search.
Question mark in the middle of the night, question mark?
And we know it couldn't have been him. But not one. Every time we see that person on the bike, we don't have cell phone activity, we don't have computer activity, and his Whoop is mysteriously and coincidentally disconnected. In fact, on that second bike, the third day, the 22nd, when there were 2 separate rides, it connected and disconnected after the first ride, and connected and disconnected after the second ride. What more do you need to see? But okay, let's talk about assumptions. How to force open my door with a crowbar. How was Becky's window forced open? With a crowbar. Can I force open my door with a crowbar if I lock myself out? How was her window forced open? How many cops in Quincy, Illinois? Respectfully enough to catch.
I don't think it was even established when these Google
How to make a
searches
homemade
were
pistol silencer?
done,
No,
were
the neighbor's
searched.
reported here in the shop. And he's looking up how to make a homemade pistol silencer. Average Quincy, Illinois Police Department response time? How long do I have to get away? How can I check if a gun is registered to me? Are the police going to be able to figure out what guns I own and if they're missing? And they're missing guns. Does my Whoop record the exact times I wear it? The Whoop data that shows that he was the person on that bike making those rides. Can you just wash off gunpowder residue? How do I hide the evidence of my crimes? Does my Whoop catch up when I'm not wearing it? Are the police going to be able to catch me? Can you find out what guns are registered to your name? Are the police going to be able to catch me? How to clean gunpowder off your hands? Are the police going to be able to catch me? Can you identify if a shotgun shell was shot out of a specific shotgun? What did we learn over the last 7 days about shell casings? Fingerprint. He was on websites for improvised silencers. He was on websites for how to open windows from the outside, just like Becky's window was forced open. How to unlock privacy locks. He was on websites for easy lock picking tricks. He was on websites for how to use a crowbar to open a door. He was on websites for can gunshot residue be washed off or wiped off. He was on a website that says gunshot powder residue not always a smoking gun. Well, we know that's true. We learned that over the last 7 days, that after 6 hours, there's really no point. Are shotgun rounds traceable? We learned the answer to handgun rounds. Every piece of evidence, every single witness points to one person and one person alone. Nothing you have seen or heard over the past 7 days shows that anyone other than the defendant committed this brutal and heinous crime. Nothing you have seen or heard over the past 7 days shows that anyone else fired those 14 bullets into Becky's body. Nothing you have heard or seen over the last 7 days shows that anyone else had a motive to kill Becky. In fact, only the defendant had a motive to execute Becky. The divorce was coming up. He thought he was going to lose. He thought he wasn't going to get what he wanted. And just like Becky predicted, he literally lost his mind. Only the defendant had the matching shell casings in his basement. Shell casings in the basement that were fired by the exact same gun that shot and killed Becky. The same fingerprint, if you will, on the shell casings surrounding Becky's body and the shell casings in his basement. The same fingerprint. The exact same gun. And only the defendant had those strange coincidental gaps on his Whoop armband. 1,478,411, I think, second by second by second by second. And the only times we heard about any gaps, the only times are when somebody's riding that bike, not somebody, when the defendant was riding that bike. And the only time we heard about those gaps are when the defendant rode that bike to Becky's house. And the only time we heard about those gaps are when he climbed up to her window and he pried open that window. And the only time we heard about those gaps are when he chased Becky down the hall, broke open the door, and knocked the phone out of her hands. And the only time we heard about those gaps are when he followed Becky into the bathroom and she fell to the ground. And he looked down at her and he looked her in the eyes and she looked up at him. And he pointed the gun down at her and he pulled the trigger once, twice, 3 times, 4 times, 5 times, 6 times, 14 times. Only the defendant is to blame for executing Becky. And in this case, there can be only one verdict. Sign the verdict form that finds him guilty of home invasion. Sign the verdict form that finds him guilty of first-degree murder. Sign the verdict form that says that he used a firearm to commit that offense. There can be only one verdict. One verdict that the evidence supports. One verdict that the law requires. And one verdict that justice demands. Find the defendant guilty.
Thank you, Mr. Jones. Before we start with the defendant's closing statement, I'm going to let everybody take a break. All right.
Gabby Rios is going to the Goodwill to donate some clutter. Yes, I have a box sitting by my front door as well going to the Goodwill. That's another thing that's really close to Target, close to my house. Target that I'm banning. And it's really hard. It's like getting rid of an addiction because, like, that's what you do. Target's right up the street. It's inexpensive. You use little cartwheel deals. I got 3 girls that are 16, almost 17, and a son who's 20. You don't think I go through a lot of grocery money? And those cartwheel deals, what's the name of that lady? Crazy Coupon Lady. So if you download the Crazy Coupons, Crazy with a K, Crazy Coupon Lady, her app, somebody on there goes through like Target, Walgreens, CVS, etc. And Target's the closest to me, and then the next would probably be Walgreens, and then Walmart is like up in Eden Prairie by the airport where the 9/11 the one guy took flying lessons. Yeah, so I really don't like Eden Prairie. I stay away from it as much as possible. Anyway, so Yeah, Target's like super. It's like right up the street. Target. There's a SNL. There's what's her name? There's a skit. Target, going to Target. Anyway, so yes, doing the Target boycott. The Target boycott is really difficult. Damn you, Target. So, but there was a Target. I'm gonna have to play that now. I can't until this is over because YouTube will throw me in the clink again. What was I saying? Oh, several years ago there was a data breach using at Target, so a lot of people boycotted them too. That was like 4 or 5 years ago. And then, yeah. Now I know as a red card holder at Target, I know that my red card points, I can pick who the red card points go to. So I always pick like veterans. So I know I saw somebody on the Twitterverse saying, oh, they donate to certain, LGBTQ, RS, TUP, or TUV, WXYZ groups. And it's up to the individual red card holder to determine where those Target donation points go. Just a little FYI. Okay, here's some questions I have for this guy. Again, the murder weapon was never found. So is there any evidence or testimony that directly links the murder weapon with the defendant? The answer is no. They never found it. I don't think there's any evidence to show that they even owned this type of firearm. And again, the 35 matching shell casings that he's talked about is the 27 found in the basement to quote-unquote match the 8 found at the crime scene. But again, Ian Runkle, if you're listening, I know you're probably really busy and maybe you're just getting home now and turning on Crime Spies, but I'm pretty darn sure you had said that because of the manufacturing process nowadays, that's if a firearm, like the firearm batch, if it's in the same batch, it would produce the same striations or what have you on the shell casings. So to say that I don't know. So there's no witnesses that saw him. The person on the bike is, a figure on a bike in the winter. I do think it's weird that the same figure on the bike is shown on the bike the night before and on the bike the night of the murder. I know I shouldn't probably say anything, but geez Louise, where's the justice in the system? And the DNA found under her fingernails, that was more likened to the DNA of the boys, which makes 0 sense because the boys, she had had surgery earlier in the week, and the boys, she hadn't seen them. So that leads me to believe, was the evidence contaminated? As far as I know, there weren't any alternative suspects or potential motives. The boyfriend, Ted Johnson, testified, but were his cell phone records, was his fitness band, was his automobile information, pulled, reviewed? Was her information reviewed to see if she was in communication with anyone other than Ted? He says he stopped over for an hour the one night. I think it was February 21st, unspecified time. He saw Becky approximately 1 hour, mentions bringing food up to her house on February 22nd. During the visit, he stayed for an hour, carried bottles of water and books up to the stairs to the bedroom, kissed the forehead, bid her goodnight, unaware it would be the last time he saw her. And then Tim asked on that same day if she could keep the kids until the 22nd, which that doesn't make any sense because she didn't have the kids. And unless she had the kids on the 21st. There was a part where he asked her because he didn't feel good. Damn. Oh, so my point is, okay, so what's to say that the guy that stopped by with the water and the food, etc., what's to say that he didn't have a motive? Maybe she was saying, you know what, I'm having this, whatever her cosmetic surgery was, and I'm sick with you. I'm you know, gonna recover, and I'm done with you and your low life, you know, non-committal. She did say she was very unsatisfied with the fact that he wouldn't commit to a, you know, one-on-one relationship. So maybe she's just like, you know what, screw you, pal. I'm going to go get my cosmetic surgery. I'm going to recover from that. And me and my beautiful self are going to go find someone who wants a commitment. And he's just like, and set up the guy. I don't know. I'm just asking questions. And here the jury's deliberating and I've still got questions. Testimony regarding, was there any evidence or testimony regarding his mental state or emotional state leading up to the incident? Not that I heard. The girlfriend came over for an afternoon delight. Seemed fine. Talked to the lady at the school. Seemed fine. Anyway, that's just some things I came up with here. Just looking to see if there's any notifications that the jury came back. There is not. And Gabby Rios in the chat is going to the Goodwill. You know, the Goodwill used to give you little receipts that would give you 15% off if you went inside. I don't know about you, but my Goodwill, the prices have gone up significantly. Like, oh, and there's a Goodwill warehouse out here. So you have to like well, I can talk about the Goodwill later, but like you have to like put on your like football padding and stuff before you go in there, because I got in a fight with a guy once over like a Gucci shoe. I had one and he had one. He goes, well, what are you going to do about it? And I just decided the Gucci shoe wasn't, I almost just bought it out of spite, actually, to be honest with you. But I just caved and said, you know, it's not worth it to me if you want to be an asshole. So I gave him the Gucci shoe.
20 minutes, and we'll start with Ms. Schnock's closing. Bliefnick is present in court argument, and if you could bring in the jury. You may be heard.
Thank you.
I really wish more people paid attention to this trial. It's been such a clusterfuck between the testimony and the tweets and the friggin' video taking forever.
What a term that is. We've heard a
Sorry,
lot
I'll start
about
her over
proof
and I'll
beyond
stop
a reasonable
talking.
doubt since last Monday. We heard proof beyond a reasonable doubt when we were picking the jury. May it please the court.
And might I say, she's kind of a rude human being. And a lot of people on Twitter just don't like her, but does that make her defendant guilty? Question mark.
Counsel, ladies and gentlemen, proof beyond a reasonable doubt. What a term that is. We've heard a lot about proof beyond a reasonable doubt since last Monday. We heard proof beyond a reasonable doubt when we were picking the jury. We heard about proof beyond a reasonable doubt during our opening statements, and you're hearing about proof beyond a reasonable doubt now. And you're hearing about it over and over, time and time again, because it's important. It is an important principle of law. I would suggest to you probably one of the most important principles of law that you will consider in your deliberations today. Beyond a reasonable doubt is a high burden. It is a very high burden. It is a monumental burden. And it is a high burden And it is done so because our founding fathers believed that it was better that 100 people guilty go free than one innocent person be convicted.
100% true.
I've heard time and time again, that burden of proof is not on me. That burden of proof is not on Tim. That burden of proof is on the state and the state alone. And because the burden of proof is on the state and the burden of proof is not on me, this is the last time that I will get to address you during the course of this trial. If Mr. Jones wants to take another stab at you at rebuttal, that's his prerogative, but this is the last time that I will get to address any of it. So I would like to take this moment to thank all of you for your patience. I thank you, Megan thanks you, and Tim thanks you for your patience. You were all asked if you could handle deciding a case like this. You all said that you believed that you could, and so we thank you for your attention to your service. And we've all been here a long time. I don't know about you, but I'm tired, so I'm going to get right to the point here. When you were selected, you were asked by the court, you were asked by Mr. Jones, and you were asked by myself if you would follow the law. You all promised that you would follow the law. You promised to follow the law if you didn't like it, and you promised to follow the law even if you didn't agree with it. And I'm going to ask you that again right now, and I'm going to ask you that on behalf of Tim, that you follow the law. Remember your promise and remember that oath. One of the first things that Judge Adrian is going to tell you when Mr. Jones and I are done addressing you is he is going to read the law to you. Sympathy should not enter in your deliberations. You will not hear anything from the judge that sympathy is a factor in any of this. As a matter of fact, you will be told that sympathy should not enter in your deliberations, and it is not something that should be considered by you when you go back into that jury room. We all feel sorry for Becky, and we all feel sorry for her family. This is sad. When somebody dies, it's sad. When somebody dies with kids, it's sad. When somebody dies tragically, it's sad. But we're not here to decide if this is sad. We're not here to prey on your sympathy. Sympathy has its place. It has its place in the theater, but it doesn't have its place in a courtroom, and it doesn't have a place in your deliberations. And I say that because sympathy is not evidence, and it cannot be considered by you, and the judge will tell you that. And the reason that I'm addressing that right now is because when you listen to the state's opening statement, and when you listen to their closing argument, both of which are not evidence, may I add, it is dripping with sympathy. It is lacking in any hard evidence. So when Mr. Jones talked to you about Becky's death and the manner in which he thinks it occurred, that should not enter in your deliberations. And I say that because it is simply a cry for sympathy because the case is lacking substantive evidence. The state is asking you to do something today. They want something from you. They want you to take away the presumption of innocence that all defendants enjoy, that Tim enjoys as he sits here right now, that he enjoyed every single day since this case was brought against him. He will carry that presumption of innocence with him unless and until all of you are convinced that the state has proven their case beyond a reasonable doubt. But as he sits here today, he is presumed innocent as a matter of law. All of you promised that you agreed to that and that you would accept that. Because Tim carries the presumption of innocence with him, and the burden of proof is not on me and it's not on Tim, he doesn't have to prove anything in this case. He does not have to prove he's innocent. He does not have to prove that he is not guilty. He does not have to prove alternative theories. This is the state's burden. It's not mine and it's not Tim's. And in order for you to take away that presumption of innocence away from Tim, you all need to be convinced that the state has given you good, solid, credible evidence that convinces all of you that each and every element of that offense has been proven beyond a reasonable doubt. I would submit to you that beyond a reasonable doubt is not in conclusions, and it is not me's. And I cannot stress this next proposition to you enough. Motive is not an element of the offense of murder. You have heard a lot about motive. You have heard evidence or lack of evidence about motive, but you are not going to be given an instruction about motive. The judge isn't going to tell you to consider motive. The judge isn't going to tell you that it is an element of the offense that has to be proven. Motive is rhetoric and is not something that should be considered in your deliberations. Mr. Jones has talked a lot about the manner in which Becky died. The fact that she won't have parenting time with her kids, that she won't receive alimony, and that she won't receive child support. But ask yourself, what does that prove in this case? The answer is nothing. It proves nothing. It proves that they were getting divorced. It proves that there were court orders entered. And all it is a request for sympathy. It does not prove anything. It certainly doesn't prove that Tim murdered her. We heard from her friends. We've heard from Becky's family members. We've heard from coworkers. They all got on the stand and they testified that sometime after the time of filing, at this point going back to 2021 now, Becky said something to the effect of, if anything happens to me, look at Tim. We heard about this from friends, from work colleagues, from people that knew Tim, from people that didn't know Tim, from people that hadn't seen Tim in years, from people that took Becky's side in the divorce. But regardless of who these people are, where they came from, or when they heard what they heard, I want you to join in their request. I ask you, look at Tim. Look at Tim right now and ask yourself, what does the evidence prove? Look at Tim and ask yourself, what hasn't been proven? Look at Tim and ask yourself, what is the lack of evidence here? What have we been shown? What evidence has been presented? And what, if anything, does that prove to sustain the state's burden of proof? I suggest and I submit to you that the state has come up woefully short in their quest to prove Tim guilty beyond a reasonable doubt. Now, we've talked about DNA. You heard about transference of DNA. You heard about how DNA of one person could get into the home of another person. And the example was the backpack. If I send my son over to Grandma and Grandpa's with a backpack, my DNA could end up at Grandma and Grandpa's, even though I had never actually been in the house. You heard about all of the evidence that was collected, all of the swabs that were done. They did DNA collection and testing on the chair outside that they believed Tim used to shimmy up the side of the house, onto the pergola, onto the roof. They did not find any DNA on any of the shell casings that you heard about. They did not find any of Tim's DNA on the bike that they think he rode to commit this crime. They swabbed his car for DNA evidence. They found nothing. There is no DNA with any reasonable degree of scientific certainty that can link Tim to this crime. None. They did their best. You heard from all of the police officers involved in this and all of the efforts that they went through to collect evidence, and they did not find anything with Tim's DNA on it that can connect him to this crime. You didn't hear about any fingerprint evidence. You did not hear about any hair or fiber samples being collected and tested as evidence. They wanted to make a big deal about the length of his hair, but didn't find any hair anywhere that they looked. You heard about all of the gloves that were taken, that were tested, that nothing was found on. You heard about the nearly 800 tons of trash that were sifted through, that nothing was found. You heard about the Aldi bag, the grocery bag that the state thinks Tim used as a silencer that can't be matched to Tim. You don't have a weapon. You have ballistics that are subject to human error, and that their own expert told you are not exact reproductions. Now, additionally, the elephant in the room, the Google searches. The state did not tell you when those were done, and they cannot tell you when those searches were done, and they cannot tell you who did those searches. If those searches took place before Becky's death, I would admit it should be considered by you for whatever that's worth. But they can't tell you that. Nobody can tell you that, and you can't guess. If these searches took place after Becky's death, then the searches should indicate that it's nothing more than Tim looking into the investigation like half of the town did, and following the investigation as the news allowed us to follow the evidence. But they can't tell us when those searches were done, and it's not my job to tell you or prove to you when those were done. These searches indicate nothing more than somebody looking on the internet. I think it's logical to do if something like this were to happen to your family. But the state wants you, each and every one of you, to speculate, and the state wants each and every one of you to guess when those searches took place. And the judge is going to tell you that you can't guess, that you can't speculate. And if you have to guess, or if you have to speculate, I submit to all of you that that is not proof beyond a reasonable doubt. If you are left guessing or wondering, the state has not met its burden of proof. And guessing is not proof beyond a reasonable doubt. The state has not provided you any witnesses. I think their first 3 witnesses and all of the neighbors said they didn't hear anything. They didn't see anything. They didn't see Tim in the area of the 22nd or the 23rd. They didn't have anything on their home surveillance video. Nothing. Nobody can put Tim in that area. There's no reliable video. We've heard ad nauseum of the efforts the Quincy Police Department went going door to door, business to business, looking for surveillance video to possibly solve this crime. Even Mr. Jones and his own witnesses agreed. You can't tell who's in that video. You don't know if this is a man or a woman. We don't know what race they are. We don't know where they're going. We don't know where they're coming from. We don't even know if this is the same person in each video, folks. And that leaves you guessing. And if you have to guess who is in that video, and if you have to speculate who is in that video, what I submit to you is that video is not proof beyond a reasonable doubt. If you look at that video, you don't see whoever that is carrying a crowbar. You don't see whoever that is carrying a gun. And you certainly don't see long, brown, flowing hair anywhere in those videos. There is no identification, and there is no proof beyond a reasonable doubt. Now I want to talk about the crowbar and the pry marks. I believe Emily Pizzella told you that there were several crowbars that were found at Tim's residence. They went through his house top to bottom, went through his car too. He told them where everything was. During Mr. Jones' opening statement, he told you that that crowbar was a match. We had our witness in court yesterday. She told you that that crowbar was inconclusive as the tool that made those marks. She could not say with any reasonable degree of scientific certainty whether or not that crowbar was or wasn't used in the commission of this crime. That leaves you with an inconclusive lab result. Inconclusive results, folks, is not proof beyond a reasonable doubt. That leaves you guessing, and that leaves you speculating, and you cannot do that. That crowbar, nobody can say one way or another if that crowbar opened that window, and that is not proof beyond a reasonable doubt. They also found the shoe print left right by the window that the state wants you to believe that Tim pried open with a crowbar that they can't link to the crime and left that shoe print. Emily Pizzella told us that there were two partial footprints, one on the end table right below the window, and then the one on the floor that we've all heard about and saw in some of the state's pictures. You heard about all of the shoes that they took from Tim's residence. They had access to every single one of Tim's shoes. They took the shoes off of him that he was wearing in the middle of Hampshire Street. They took pictures of his shoes the night Becky was murdered. They took pictures of Ted Johnson's shoes, and the only thing that all of that came to was that Tim's shoes were excluded as making that footprint. Excluded. There are no footprints, no shoes, no nothing that can link that print to Tim Bliefnick in any way, shape, or form. That wasn't inconclusive, that was excluded. There has been literally no evidence in this case, folks, that Tim committed this crime. There's been a lot of evidence of motive, but not a lot of evidence that a crime was committed. And that's in spite of the good work of Quincy Police Department, especially Emily Pizzella. You heard from her and other officers, and they told you how many hours they spent going through Becky's house, searching the outside of Becky's house. I think Emily said she even went back to Becky's house and so that she could try to find more evidence. Emily was involved in searching Tim's house, top to bottom, inside and outside, garages, trash. They found nothing. They went door to door, house to house, business to business. They found nothing. They collected swabs and samples, and they secured every single piece of evidence, and they sent everything off to the crime lab for testing that they possibly could. And in our opinion, their hard work and the lab's hard work clearly exonerates Tim. In addition, and I think this is important to point out to you, that there was a prowler next door to Becky's literally 24 hours beforehand, and nobody bothered looking into that. And you heard that from Taylor Hyman, who lives right next door to Becky. He's the one that told you the only reason he even had security cameras to begin with is because he had people breaking into his cars. He told you that a week before, they had somebody trying to break into their car. He told you that they posted it on social media. He told you that him and his wife said, "Hey guys, he's back." Nothing about Tim Bliefnick being in his driveway. It was the prowler, as the Hymans told you. Now let's look a little bit further into the state's theory of the case. When you watch those videos and when you look at who is on that bike, you cannot say with any degree of certainty that that is Tim. Where's the crowbar? Where's the gun? You don't see any of that. The theory is that Tim took the crowbar and the gun from his house to Becky's house and back. But even Mr. Jones agrees that that's not an identifiable individual on that video, and that's not proof beyond a reasonable doubt. As far as that bike is concerned, they want you to believe that he rode this mystery bicycle from his house at 16th and Hampshire to her house at 25th and Kentucky Road. But the evidence really is that somebody was riding a bike by the bus barn at 20th and Hampshire, and somebody was riding a bike at 20th and Prairie, but that's hardly in the neighborhood of Tim's house, and it certainly isn't in the neighborhood of Becky's house. We've looked at every residential camera, every business camera, every security camera between Tim's house and Becky's house, and have found nothing but the short blurbs of somebody who is clearly not Tim riding a bicycle. That is not proof beyond a reasonable doubt. Following that theory is that Tim broke into his own home, doing it the most difficult way possible. Common sense, and none of you are required to check your common sense at the door, tells us that if you're going to break into your own home, you're going to do it the easiest way possible and not the most difficult. You're not going to climb up a chair and shimmy up the side of the house and go from a pergola to a roof and walk past your wife's bedroom window in the process. It doesn't make sense. The next thing that you need to consider is that in the opening statement that the state gave you, they told you that the crowbar matched the pry marks. Now you've heard scientific evidence that shows that the crowbar and the pry marks do not match, and they are at best inconclusive. Now I want to talk about the shoe print, and I'm almost done, folks, so please bear with me, but this is important. The state's theory is that the killer broke through that bedroom window and left a shoe print on the carpet. The police cut that shoe print out, and they sent it in for analysis. And that shoe print that was sent in for analysis was compared to the shoes for Tim, and it's not Tim's shoe. It wasn't inconclusive, it was excluded. Now, Mr. Jones wants to submit that that only eliminates Tim's shoe. But they took all of his shoes and they didn't even bother testing the remaining shoes, or anybody else's shoes for that matter. Since it's the state's burden of proof and they cannot bother to test the remaining shoes, I think that in and of itself should create reasonable doubt in your mind. I also think the fact that Mr. Jones wants to turn this into a game show should tell you what he thinks about his evidence and that it is lacking substance. What I submit to you is if the killer went through that window and left that shoe print, which I can almost certainly concede that happened, and the state appears to agree with that, that shoe print is not Tim's, and that, ladies and gentlemen, is reasonable doubt. Now let's follow through. The state can't give you the murder weapon. They can't give you any DNA that sufficiently links him to this crime. They have been unable to produce any hair or fiber samples. You've heard nothing about any gunshot residue tests that were offered to Tim, and you won't hear anything about that. And the state wants you to believe that Tim did all of this while his 13-year-old, his 10-year-old, and his 5-year-old were home alone in his care at his house, and that he did all of this in order to avoid paying child support and alimony. But the fact of the matter is, Tim had been paying child support and he had been paying alimony, and he was willing to continue to pay alimony. He was willing to continue to help the boys out financially. You saw the letter. He wasn't trying to get out of his responsibility. You saw the settlement letter. And you also heard from the guardian ad litem, Rick Zimmerman, who is an important person in all of this because he really truly is the one independent person who testified to anything. He was appointed in the divorce to protect the best interest of Tim and Becky's boys. And he told you, along with several other witnesses, that there was animosity. But it was animosity on both sides. But it was Rick's job to protect the boys' best interest. It was Rick's job to listen to the safety concerns. It was Rick's job to report to the court anything that was going on in that household that could potentially affect the best interest of those kids. And Rick told you there were no red flags. He told you there was no domestic violence. He told you that these two would make mountains out of anthills. But he also told you that they were able to work things out in the end. They were able to work things out to such an extent that they had both agreed to the current parenting plan that they were operating under, even though neither one of them liked it. And they agreed to that schedule without attorney involvement. They agreed to that schedule without court involvement. They agreed to that schedule without the input of the guardian ad litem. And they did it because it was working for the boys. Neither one of them liked it, but they were willing to go along with it. And when both parties are unhappy in a divorce, you probably have a fair agreement. And that's what Mr. Zimmerman told you. In addition, there were no orders of protection that you heard about. There was no police involvement that you heard about. You didn't hear about the police having to come to Becky's house to break up a fight. You didn't hear about the police having to go to Tim's house because he was refusing to send them out. You didn't hear about any of that. The only thing that you heard was divorce talk. The girl talk at work, blowing off steam about her husbands, blowing off steam about the divorce, joking. I think is what Sarah Murphy said, that they were joking. You heard from Ted Johnson, he was unaware of anything that Becky was scared of leading up to her murder. All of that is divorce talk, folks. It's rhetoric. It doesn't prove anything to you other than what we already know, and that's that they were getting divorced and there was animosity. But what does it prove in this case? Ask yourself that. What does it really prove? And what I submit to you is that hearsay statements that are nearly 2 and 3 years old are simply divorce talk. They are rhetoric. They are not proof beyond a reasonable doubt. Listen to Rick Zimmerman. No red flags. He was the one person or a person that Becky could have gone to during any of this and said, I'm scared, and this is why. She could have gone to Jerry Timberwolke. I'm scared. This is why. You didn't hear any evidence of that happening. No red flags. That is not proof beyond a reasonable doubt. And finally, I want to draw your attention to the last conversation that Tim and Becky had. She told Tim, not her mom, not her dad, not her coworkers, not her sisters. She told Tim that she was ill and asked him if he could keep the boys. And he said, yes, I will. Do you want me to take them to school in the morning? And he said, yeah, I would, or some words to that effect. There's no hate there. There's no fear there. This is how you want divorcing people to act. You want divorcing people to be able to handle scheduling changes. You want divorcing people to be able to handle their kids at the last minute. That's not murder, folks. Becky went to Tim when she needed him as one of her last acts, and he accommodated her. He accommodated her without argument. He accommodated her without question. As I said, this isn't a Lifetime movie. This is real life. The state has given you a great motive, but they haven't given you any substantive evidence to back that up. I suggest to you that the only verdict in this case should be not guilty. And I request that when you go back there, you look at the evidence, you read the law, you avoid sympathy, and find Tim not guilty. Thank you.
Thank you, Ms. Schnock. Mr. Jones.
Thank you, Your Honor. I know it's been a long day. I know you've had a lot thrown at you in the past 7 days. I have 7 points that I want to make in rebuttal and an end to that, and then we'll be done. The first point I want to make is what the defense just touched on, that Becky texted Tim on Our Family Ways about the boys and said, not feeling well, you watch the boys, and that's what we want divorcing people to do. I don't know, but what I do know is that when Becky sent that message, she showed weakness to a predator. Ethan knew she wasn't feeling well, and he knew she'd be home alone, and he knew he'd have an opportunity.
There's a verdict.
The second point I want to talk about is something that the defense said about the program and my opening statement, and that I said. I think if you think about what was said, what I said was exactly what the witness said, that there were microscopic consistencies between the tool mark and the tool. Nobody said it was a match. She can't say it's a match, just like Jim Riggins couldn't say the Aldi bag was a scientific match. But just like you saw those Aldi bag pieces on top of the Aldi bag and saw what that meant to you, the crime lab individual who looked at the tool and the tool mark said that there were the same microscopic consistencies between that crowbar and the tool mark. And the only reason she couldn't call it a match is because she couldn't recreate the exact, precise conditions that the mark was made in. My third point about the shoe print is correct. He took all the shoes that the defendant had on him. And what he didn't have on him, the shoes that he used when he climbed through that window and got the shoe. We can't test against those shoes because he got rid of them. The defense says that the burden of proof is high, and it is. But it's a burden of proof that is met every day through courtrooms across this great nation. The defense says that we are lacking in evidence. I would submit to you that WHOOP data, lack of cell phone activity, computer data, the video, the bike, the DNA, Becky's statements, all that is evidence. Is each piece of evidence in and of itself enough to convict the defendant? Absolutely not. The videos that you saw, just those videos, if that's all we had, you should absolutely go out here and find him not guilty. if it was just the videos. But it's not just the videos. It's the videos and how they relate to the loop data, and how they relate to the cell phone data, and how they relate to the computer activity, and how they relate to the searches that he made at 1 o'clock in the morning on February 14th. Yeah, there was a prowler in Taylor Hyman's yard. The prowler's right there. We know he sits right there because he was searching for the car that was in Becky's backyard at the same time. It wasn't a random prowler, it was the defendant. And we know that because every piece of evidence fits together to show it. The defense says we're lacking in evidence. What about the shell casings? The defense says, well, the shell casings, that's human error. Human error? First, it was a peer review process. Other people had to confirm her testimony.
If you didn't hear me, there's a verdict. I'm watching Muddy River News. Becky's family filtered into the courtroom about 1 minute ago. It's 5:14 p.m. Central Standard Time. And about a half a minute ago, Tim's family entered the courtroom. Obviously, we're not going to get the video.
And she told you in 26 years.
I'm going to have to speed up this guy.
Every test that she took, 100%. Every test she took, she had to score 100% or she got fired. 26 years. Human error? Was there animosity in this, of course? Absolutely there was. There was animosity on both sides. Folks, only Becky is dead. Only Becky was murdered.
This makes me nervous,
Last point
people.
is this. And it goes to the searches on the cell phone. The defense says maybe the searches were done after Becky was found murdered. One of the things about this trial he's been complaining about is how tight we've been. Information hasn't been released to the public. If he was searching for this information after Becky was murdered, how did he know that crowbar was used? He just got lucky and guessed. How did he know to even look about gunshot powder residue? He just got lucky and guessed. Nobody knew that a crowbar was used. That wasn't released to the public. Nobody knew that a window was used. That wasn't released to the public. Nobody knew that the neighbors didn't hear shots. That an improvised silencer might have been used. That wasn't released to the public. None of those things are released to the public, but they all appeared on his phone. They all appeared on his phone. Searching for Quincy police response time? He's searching for whoop data? And it just so happens to turn out coincidentally, by some stroke of bad luck for the defendant, that his whoop is not recording every single time we see the person on the bike. Every single time. If there was one time when that didn't happen, one time, then he's not the guy. If there was one cell phone call when any of that happened, then he's not the guy. If there was one Google search when those things happened, then he's not the guy. If there was one text message when all those things happen, then he's not the guy. But there's not. And do you know why there's not? Because he's the guy. When this trial started on May 23rd, 2023, exactly 3 months after the defendant shot and killed Becky, shot her 14 times on that bathroom floor, 14 times. One time for every year that they were married. And he left her for dead to slowly bleed to death, unable to move from the waist down, unable to breathe because a bullet pierced her lung, but still alive. We talked about how we could never know what was going on in her mind. We never know what Becky's life was. We know she was in pain. We know she was scared, but we don't know what she was thinking. Was she thinking about her mom and dad burning Bill? Her sister Sarah? Her boyfriend Ted? Was she thinking about her 3 boys, Deacon, Braylon, and Arson? Was she thinking about
Tim and attorneys just entered.
We won't ever know. But you know what we do know? You know what she wasn't thinking? She wasn't thinking, how could this happen? She wasn't thinking, how did I get here? She wasn't thinking, how could my husband do this?
This really
She wasn't
sucks.
thinking
We
that because
can't
folks, she
see the
predicted
video
it.
in live time.
She knew this was going to happen. She was scared of the defendant. She was scared that he was going to hurt her, that he was going to kill her. She asked for help. This strong alpha female pleaded for help. The single mother who would rather struggle than to look weak, she begged for help. She begged for protection from the defendant. And her pleas, her prayers, her tears, they all went unanswered. We failed her. Her friends, her family, the community, the system, we failed Becky Bliefnick. She called Gary Collins, a police officer, in tears. And she told him, if something happens to me, it's going to be the defendant that did it. You know what about? She got a pat on the head. They're there, it's going to be okay. He'd never do that to you. But Gary was wrong. She called out to her friends across the country. And she said the defendant was going to eliminate her as a choice. That the defendant was becoming more vengeful and unpredictable, and that it was a fucking nightmare. That if he didn't get his way, he might literally lose his mind. That he wanted her to suffer. That he was going to go off the deep end. She told her friends that if anything happens to her, it was the defendant that did it. I don't know. Maybe your friends thought it was all divorce talk. Girl gossip. But it wasn't. It was a woman crying out. She needed help from her attorneys. She told them she needed help. She told them she needed protection. Protection from the defendant. What did she get? She got court orders, continuances, and delays. I don't know. Maybe your attorneys thought this doesn't happen in place. People don't get murdered in divorces. But her attorneys were wrong. She needed protection. Protection from the defendant. She cried out to her family. She knew the defendant was going to harm her. She put it in writing that she was scared of him. That the defendant was going to do something to take her away from her kids. Or the kids away from her. That the defendant would lie about her and try to paint her as something she wasn't. She told them that the person who would do something to her was the defendant. And while the only person to blame for what the defendant did to Becky, the only person to blame for pumping 14 bullets into her body while she lay on the floor with her hands in front of her face, the only person to blame for that sits right there in front of you. But we all failed her. Her friends, her family, her community, we failed her on February 23rd, 2023. When she wept, we turned a blind eye. When she cried out, we turned a deaf ear. When she asked for help, we turned our backs and walked away. But it's not February 23rd, 2023 anymore. Today is May 31st, 2023. 98 days since Becky was left alone in that dark, cold bathroom, and pain and terror slowly bleeding to death. Today is May 31st, 2023 anymore, and Becky isn't calling out for help. She isn't calling out for sympathy.
Oh,
She isn't
oh,
calling
oh,
out
oh.
for you to
Sorry. I just noticed that Muddy River on their Facebook. Okay, I had to shut that guy off because the verdict is going to get read, and I just noticed, it dawned on me. I thought I saw Muddy Rivers post something about Facebook, and then I actually logged into my Facebook earlier.
We are on the record on 23 CF 170 People versus Timothy Bliefnick.
I don't know why they didn't do this to begin with.
Present in
So it's the verdict,
court, along
people.
with his attorney, Miss Casey Schnock. People are present by Assistant State's Attorney Josh Jones and Laura Keck. And I am told the jury has reached a verdict. And Mr. Jones, anything before we bring the jury in?
Just remind everybody don't turn their cell phones on.
Yes, I guess I will. Ladies and gentlemen, you're allowed to have your cell phones in the courthouse. However, when you are in the courtroom, they must be turned completely off. That means completely off, not on silence, not on vibrate, not in airplane mode. They must be completely off because and they must be put away because if the security sees that you have your cell phone on or your cell phone goes off, you will be removed from the courtroom and will not be allowed back in today. That does not include the media, which of course are allowed to have their devices out so they can communicate with the public, but they need to be wearing their badges so that they are identified as media and so security will not hassle them. And then, Mr. Jones, anything else before we bring the jury in?
No, Your Honor.
Ms. Schnock?
No, Your Honor.
Okay, let's bring in the jury.
There we go. What do you think, people? It's awful quick, 4 hours. Well, at least we get to see this. Let's try to get a better view. That's not any better. It's as good as we're gonna get, I guess.
All right, which juror has the paperwork? All right, juror number 6. I take it you are the foreman then? And has the jury reached its verdict? Okay, and if you could hand that paperwork to the bailiff. To the clerk. Would the clerk read the verdicts, please?
We, the jury, find the defendant, Timothy Bliefnick, guilty of home invasion signed by the 4 persons
Guilty.
and 11 jurors. We, the jury, find the defendant, Timothy Bliefnick, guilty of
Guilty.
murder signed by the 4 persons and 11 jurors. We, the jury, find the allegation that during the commission of the offense of first-degree murder, the defendant personally discharged a firearm that approximately caused death to another person
like to have the jury polled?
No, Your Honor.
All right. Ladies and gentlemen of the jury, I thank you for your service. You will need to head back then to the jury room and wait there for just a couple minutes, and I will be in to talk with you shortly thereafter, all right? All rise.
Well, you know how I feel. Let's just listen a little bit longer.
The court enters judgment on the verdicts, and then the defendant has been held without bond. The court will continue holding the defendant without bond until sentencing, and we will pick a sentencing date.
Heaven forbid they find a microphone anywhere close to the lady that read the verdict or the...
Did you say anytime between the 9th and the 7th?
Oh man, did they cut it off?
I can give you the afternoon of August the 11th at 1:30. I'll give you all afternoon. You think we
August the
need more than
11th at
that,
1:30 for sentencing.
Jones?
I wouldn't think so, Your Honor. I assume we'll take up any post-trial motions and this thing.
We'll take up any post-trial motions, and I'll get to that in just a minute.
I would think the afternoon would be fine.
Ms. Schnock, do you agree?
That would be fine.
All right, and the 11th works for you at 1:30?
It does.
Yes. The court is going to order the pre-sentence investigation report be done, but the clerk doesn't, we don't have them in this courtroom, so the court will enter that tomorrow, so that we will have that written order. And then Ms. Schnock, do you want more than 30 days to file any post-trial motions, or is 30 days going to be sufficient for you?
I would request 45.
45 days?
No objection to that, Your Honor.
She's asking for 45 days instead of 30
So,
to file any post-trial motions.
They're doing the
How
family presser in
about
the courtroom. I don't know if
by,
that matters to you.
In here?
Yeah.
the end of business on July the 21st?
That works.
Right?
So she has till the end of business on July 21st, he said.
Glad they're doing it there, it's rather than outside. Don't smile, because I'm gonna be covering the coverage of it. Just don't get that. How do you think I wear it? You're getting burnt.
I spelled his name wrong. Oops. Hi, Booper.
And then, Mr. Jones, anything else we need to take up?
Nothing for the people, Your Honor.
Anything from the defendant, Ms. Schnock?
No, Your Honor, thank you.
All right, we will be adjourned. All rise.
That's it, people.
yeah, you can do it. You could do it.
Okay, that concludes our coverage of the Tim Bliefnick trial. It started last Monday with juror selection. Tuesday was the beginning of witness testimony. The witness testimony ended yesterday after a long 3-day weekend. The defense chose not to have any witnesses nor have any evidence. This morning we started off with closing arguments from the prosecuting team, then the defense, and then I cut off the prosecutor's rebuttal. They deliberated for around 4 hours and came back with guilty of all charges. He was found guilty of 2 counts of murder in the death of Rebecca Bliefnick, February 23rd, in the early morning hours of February 23rd. And the other charge was home burglary. I don't know, people. I would really hate to be on trial for committing a crime when there's no murder weapon, there's grainy video footage, and they're relying on divots in fitness tracker / cell phone activity in the middle of the night to convict a man for murder. And then heaven forbid they go back and look at like of course, I've been divorced quite a while now. I don't know. I don't know, people. I mean, there was some coverage of this because he was in a game show, but he was, legit answering a question. What's the biggest mistake you made at your wedding? And he said, saying I do, which did get a lot of buzz. But again, he was trying to answer a question. Maybe Family Feud shouldn't have had that question up on the board. I don't know. I would think, I don't know. I don't know. I lost 2 followers during this afternoon live stream, so apparently I'm pissing some people off. I don't know what to say. I think open discussion is healthy for people. So that's the end of this. Boy, I sure hope that next trial that we cover, I wasn't sure if I was going to cover like live streaming trials, but considering this was really the first one I was kind of preparing for, and it came up so quickly after Letitia, I thought, well, yeah, what the heck. And it was really interesting. It got a lot of buzz, like I said in the beginning, because of the whole Family Feud Inside Edition dredged up that video. But then I think people lost interest after the trial was, you couldn't even see the video until the day after. I don't know. I don't know. I was kind of thinking maybe it would be hung. But like I said, we've been getting the tweets through, or the trial coverage through tweet, and then corroborating the tweets with the video the next day. So maybe I missed something. But even the defense attorney, Schnack, in her closing arguments, had said, the burden is on the state, and our founding fathers said it's better to let 100 guilty men go than let one innocent man go to prison for something he didn't do. That's why the burden is on the state, and it's beyond a reasonable doubt. If there's a hint that you think he corroborated with someone else and had someone else do the bidding, if you think there's a hint that the burglar that was breaking into the across the street neighbor's vehicle just a week before could be responsible for going in there, if you think there's a hint, then it should have been not guilty. Beyond a reasonable doubt. I don't know. Again, I'm an accountant with 4 kids, but I watch a lot of true crime. But that's the kind of people that make up these juries. I would have held out. So, there you have it, people. The end of trial number 2. I was going to look and see if there's any subcommittee hearings that Jim the Bulldog Jordan is going to be heading up tomorrow. I know Gabby Rios was questioning if I'm going to be doing any of those. So that's next up. Me, after I get done with this, seeing what's next up for that. Again, I've been emailing Rumble every single day asking, can I please have more than one live streaming slot at a time so people can see, is she going to have a book this morning? Is she going to have a new trial? Has she started her Covfefe and crime thing in the morning yet? Because I want to do that. That'll be kind of a potpourri of true crime stories. I really need to get on the 2 missing women in Minnesota here. There's one about 2 hours south of me, Madeline Kingsbury. She's been missing for quite a spell now. And then just within the last week, there's a younger gal up in Forest Lake, about an hour north of me, who is now missing. So that'll be part of... I don't think those will be part of Covfefe and Crime, because Covfefe and Crime is going to be more like morning as you're starting your day. What's the latest on criminal trials? What's the latest on if Hunter Biden is going to be indicted yet? What's the latest on, political crimes, true crime crimes, new missing people, questions on the Jesse McFadden complete weirdness. So that's going to be kind of like a half an hour, morning recap thing. And then I want to start doing some like not undercover, but like nighttime longer ones. Because especially graphic is this whole Jesse McFadden, Oklahoma situation. So I don't know where they're getting at down there. But yeah, the Madeline Kingsbury one and this new gal up in Forest Lake that's missing. I should try to keep some of my crimes local, eh? So with that, I tomorrow morning will be uploading more of the audiobook. I'm going to look at the chapters between Red-Handed Peter Schweitzer and Trump Art of the Deal. I think Art of the Deal is getting more interaction, so I might just pursue that. This morning, I only did a really quick video on chapters 5 and 6 because I had to prepare for this trial video, etc., etc. We had to watch the closing arguments this morning. And then, we had to watch witness testimony from yesterday. That's what it was. And then in the break, I did chapter 7 of Art of the Deal. And then I came back on and did this, which was closing arguments and verdict. Actually, the timing of that was great. Hi, TK Phillips. You're welcome. Thanks again for streaming on Rumble. You're welcome. Did you see I lost 2 followers? I think my opinions on this trial were a little off-putting. But hey, don't have a debate with Crime Spies. Just unfollow. I mean, isn't that what it's all about? I don't know. I could be wrong. Gabby Rios was here earlier. She left to go to the Goodwill. I need to do that. I have a giant box by the front door. It's so big. The reason I haven't brought it is because it's too big to carry, so I have to find some smaller boxes. Alrighty, people. So get ready for more audiobook tomorrow. And usually the House Judiciary does have a live stream on Thursdays. I couldn't find one last Thursday. So I don't know what the deal is, but I'm going to see if there's one tomorrow. And then now that this trial is over, we'll see if I can't get Covfefe and Crime jump started. I should just turn on the camera in the morning and say, well, this is going to be episode 1 of Covfefe and Crime. Let's kind of go through and figure it out. I'm better at that, I think, anyway. All right, Crime Spies, have a wonderful, wonderful day. And we will see you very soon. Oh, here, let me show you my background for Covfefe and Crime. It's a cup of coffee. I don't think you can see it. That'll be my Covfefe and Crime. Ooh, and then the nighttime one. Huh? Get better, get better, get better. All right, later, Gator. We'll see you soon. Doo-doo.
Thank you so much for spending part of your day with me. If you enjoyed the content, please hit that like button. Share this video on your social media. Subscribe to our channel. Turn on those important notifications. Follow us on Twitter. This channel is new, so that means we work for free. Any support is most appreciated through Rumble Rants, Venmo, or Buy Me a Coffee. All links are in the description box below. I look forward to your next visit to Crime Spies. Thanks again so much and have a blessed day.
Psych, I faked you out. I forgot to show you. So remember the other day I showed you Absurd Beats, his song. Fart. I had to do this again. Hold on. His song was gone. So I asked him earlier, where did your song go? And he said he's working with a distributor now for that song. And the reason why it's just a snippet here is because it's on iTunes and Spotify now. And if you go to the YouTubes, and search it up, I always forget how to spell it. Okay, so now if you go into YouTube in here, then he gets it's monetized now. But on iTunes it's only 99 cents. So make sure to go do that now for Absurd Beats. Then, okay, so I think I actually told you this earlier. A friend of mine is the brother of the bass player of the Jayhawks in Minneapolis. So I asked him earlier to listen to the song, or I said, hey, do you know anybody in Minneapolis that that you think could help get this song on the radio? And I said, I'm thinking like The Current, which is like an alternative, old, alternative, new. I think that's the best spot for it. Anywho, so he said off the top of his head he couldn't think of anybody right now, but he's going to let it marinate for a few days and wanted to listen to it. So, shout out to Absurd Beats. Let's hope we can get... Oh, and then I put the link to the YouTube video on Twitter and tagged The Current, saying any chance you can get this on the radio for a UK music producer. Honest to God, I had this song in my head for days. I've almost memorized the whole thing. So there, now I'm done. But wouldn't that be cool if we could figure out like how to get it on the radio? But now at least it's on iTunes and Spotify, so I can blare it outside. Isn't that awesome? And in the car. Very cool. So send out some good juju for Absurd Beats. Okay, now I'm finished. Have a wonderful day. Goodbye.